Alrighty, so anyhow, I figured I'd, now that it's getting all nice and warm here in Arizona, and that sun just beats my ass, man. I get late night leg cramps that aren't no fun. So anyhow, you start paying attention to your water intake when it gets hot around here. So anyhow, but yeah, now that it's all nice and hot, I came inside. So I've been very interested in studying Sir William Blackstone and showing how what American law was actually all about versus what it is today. So anyhow, that's kind of the topic. Let me just, if anybody wants to come in and talk about it, I'm going to go ahead and post the link. Oh, what's that? Pin it. Bada boom. Alright. So now, go ahead and share. This thing's always in my way. Alright. Would highly encourage everybody to start looking into these old Edison nickel iron batteries for solar applications. This looks like a real good way to go. Funny, all these buried technologies. So anyhow, let's see here. Where is my deal? Boom. Alright. So we're just going to listen in on, because this guy had major influence over our founding fathers. They all absolutely studied William Blackstone and understood what law was all about, which is why they told King George where he can go, because he was breaking the laws as a king. So this is, again, why America is founded on the principle that, nobody is above the law. The law is the law of the land, and even the king has to obey the law of the land. So, that's the deal, yo. We're ruled by law, not by a king. And not by politicians.
On the Study of the Law. Part 1. Mr. Vice-Chancellor and Gentlemen of the University, the general expectation of so numerous and respectable an audience, the novelty, and, I may add, the importance of the duty required from this chair, must unavoidably be productive of great diffidence and apprehensions in him who has the honor to be placed in it. He must be sensible how much will depend upon his conduct in the infancy of a study, which is now first adopted by public academical authority, which has generally been reputed, however unjustly, of a dry and unfruitful nature, and of which the theoretical, elementary parts have hitherto received a very moderate
Okay, anyhow, I just wanted to point out how at this time in print, all of the S's look like an F. So it's, little details like this as to why, why'd they revise the King James Bible? Because of things like this. So anyway.
share of cultivation. He cannot but reflect that, if either his plan of instruction be crude and injudicious, or the execution of it lame and superficial, it will cast a damp upon the further progress of this most useful and most rational branch of learning, and may defeat for a time the public-spirited design of our wise and beneficent benefactor. And this he must more especially dread, when he feels, by experience, how unequal his abilities are.
Also, another motive for me actually, posting this to show and prove that I have been through the material. We have it on record because I'm sick and tired of, for lawyers, where did you go to law school? You know what I mean? I'm tired of that attitude. I really am. Our society is absolutely plagued by this type of attitude. And I'm telling you, that is one of the systems of corruption within our education system. Is it's a big ego feed. The whole graduation ceremonies and everything. In my opinion, this is a method to keep puffing you up, making you believe you know your shit when you were taught what to think, not how to think.
Unassisted by preceding examples, to complete, in the manner he could wish, so extensive and arduous a task, since he freely confesses that his former more private attempts have fallen very short of his own ideas of perfection. And yet the candor he has already experienced, and this last transcendent mark of regard, his present nomination by the free and unanimous suffrage of a great and learned university, an honor to be ever remembered with the deepest and most affectionate gratitude, these testimonies of your public judgment must entirely supersede his own, and forbid him to believe himself totally insufficient for the labor at least of this employment. One thing he will venture to hope for, and it certainly shall be his constant aim, by diligence and attention to atone for his other defects, esteeming that the best return which he can possibly make for your favorable opinion of his capacity will be his unwearied endeavors in some little degree to deserve it. The science thus committed to his charge, to be cultivated, methodized, and explained in a course of academical lectures, is that of the laws and constitution of our own country, a species of knowledge in which the gentlemen of England have been more remarkably deficient than those of all Europe besides. In most of the nations on the continent, where the civil or imperial law under different modifications is closely interwoven with the municipal laws of the land, no gentleman, or at least no scholar, thinks his education is complete till he has attended a course or two of lectures, both upon the institutes of Justinian and the local constitutions of his native soil, under the very eminent professors that abound in their several universities. And in the northern parts of our own island, where also the municipal laws are frequently connected with the civil, it is difficult to meet with a person of liberal education who is destitute of a competent knowledge in that science, which is to be the guardian of his natural rights and the rule of his civil conduct. Nor have the imperial laws been totally neglected, even in the English nation. A general acquaintance with their decisions has ever been deservedly considered as no small accomplishment of a gentleman, and a fashion has prevailed, especially of late, to transport the growing hopes of this island to foreign universities, in Switzerland, Germany, and Holland, which, though infinitely inferior to our own in every other consideration, have been looked upon as better nurseries of the civil, or, which is nearly the same, of their own municipal law. In the meantime, it has been the peculiar lot of our admirable system of laws to be neglected, and even unknown, by all but one practical profession, though built upon the soundest foundations, and approved by the experience of ages. Far be it from me to derogate from the study of the civil law, considered apart from any binding authority, as a collection of written reason. No man is more thoroughly persuaded of the general excellence of its rules, and the usual equity of its decisions, nor is better convinced of its use as well as ornament to the scholar, the divine, the statesman, and even the common lawyer. But we must not carry our veneration so far as to sacrifice our Alfred and Edward to the manes of Theodosius and Justinian. We must not prefer the edict of the praetor, or the rescripts of the Roman emperor, to our own immemorial customs, or the sanctions of an English Parliament, unless we can also prefer the despotic monarchy of Rome and Byzantium, for whose meridians the former were calculated, to the free constitution of Britain, which the latter are adapted to perpetuate. Without detracting therefore from the real merit which abounds in the imperial law, I hope I may have leave to assert, that if an Englishman must be ignorant of either the one or the other, he had better be a stranger to the Roman than the English institutions. For I think it an undeniable position, that a competent knowledge of the laws of that society in which we live is the proper accomplishment of every gentleman and scholar, and highly useful, I had almost said essential, part of liberal and polite education. And in this I am warranted by the example of ancient Rome, where, as Cicero informs us, the very boys were obliged to learn the 12 tables by heart, as a carmen necessarium, or indispensable lesson, to imprint on their tender minds an early knowledge of the laws and constitutions of their country. But, as the long and universal neglect of this study, with us in England.
Funny how come we don't do that here in America? You don't teach... kids should be started at age 13 to start learning law. That is my position.
Seems in some degree to call in question the truth of this evident position. It shall therefore be the business of this introductory discourse, in the first place, to demonstrate the utility of some general acquaintance with the municipal law of the land, by pointing out its particular uses in all considerable situations of life. Some conjectures will then be offered with regard to the causes of neglecting this useful study, to which will be subjoined a few reflections on the peculiar propriety of reviving it in our own universities. And, first, to demonstrate the utility of some acquaintance with the laws of the land, let us only reflect a moment on the singular frame and policy of that land, which is governed by this system of laws. A land, perhaps the only one in the universe, in which political or civil liberty is the very end and scope of the Constitution. This liberty, rightly understood, consists in the power of doing whatever the law permits. Footnote: Facultas eiut, quodcuique facere libet, nisi quid vi aut iure probibetur. End footnote. Which is only to be effected by a general conformity of all orders and degrees to those equitable rules of action, by which the meanest individual is protected from the insults and oppression of the greatest. As therefore every subject is interested in the preservation of the laws, it is incumbent upon every man to be acquainted with those, at least, with which he is immediately concerned, lest he incur the censure as well as inconvenience of living in society without knowing the obligations which it lays him under.
The EL is a hand-cranked, height-adjustable table. The unit adjusts from 30 to 42 inches.
And thus much may suffice for persons of inferior condition, who have neither time nor capacity to enlarge their views beyond that contracted sphere in which they are appointed to move. But those, on whom nature and fortune have bestowed more abilities and greater leisure, cannot be so easily excused. These advantages are given them, not for the benefit of themselves only, but also of the public, and yet they cannot, in any scene of life, discharge properly their duty either to the public or themselves, without some degree of knowledge in the laws. To evince this the more clearly, it may not be amiss to descend to a few particulars. Let us therefore begin with our gentlemen of independent estates and fortune, the most useful as well as considerable body of men in the nation, whom even to suppose ignorant in this branch of learning is treated by Mr. Locke as a strange absurdity. It is their landed property, with its long and voluminous train of descents and conveniences, settlements, entails, and encumbrances, that forms the most intricate and most extensive object of legal knowledge. The thorough comprehension of these, in all their minute distinctions, is perhaps too laborious a talk for any but a lawyer of profession. Yet, still the understanding of a few leading principles relating to estates and conveyancing may form some check and guard upon a gentleman's inferior agents, and preserve him at least from very gross and notorious imposition. Again, the policy of all laws has made some forms necessary in the wording of last wills and testaments, and more with regard to their attestation, and ignorance of these must always be of dangerous consequence to such as by choice or necessity compile their own testaments without any technical assistance. Those who have attended the courts of justice are the best witnesses of the constitution and distresses that are hereby occasioned in families, and of the difficulties that arise in discerning the true meaning of the testator, or sometimes in discovering any meaning at all, so that in the end his estate may often be vested quite contrary to these his enigmatical intentions, because perhaps he has omitted one or two formal words, which are necessary to ascertain the sense with indisputable legal precision, or has executed his will in the presence of fewer witnesses than the law requires. But, to proceed from private concerns to those of a more public consideration, all gentlemen of fortune are, in consequence of their property, liable to be called upon to establish the rights, to estimate the injuries, to weigh the accusations, and sometimes to dispose of the lives of their fellow subjects, by serving upon juries. In this situation they are frequently to decide, and that upon their oaths, questions of nice importance, in the solution of which some legal skill is requisite, especially where the law and the fact, as it often happens, are intimately blended together, and the general incapacity, even of our best juries, to do this with any tolerable propriety, has greatly debased their authority, and has unavoidably thrown more power into the hands of the judges to direct, control, and even reverse their verdicts, than perhaps the Constitution intended. But it is not as a juror only that the English gentleman is called upon to determine questions of right, and distribute justice to his fellow subject. It is principally with this order of men that the commission of the peace is filled. And here a very ample field is opened for a gentleman to exert his talents, by maintaining good order in his neighborhood, by punishing the dissolute and idle, by protecting the peaceable and industrious, and, above all, by healing petty differences and preventing vexatious prosecutions. But, in order to attain
Understand a little why your American judges used to be justice of the peace? They ain't justices of the peace no more.
these desirable ends, it is necessary that the magistrate should understand his business, and have not only the will, but the power also, under which must be included the knowledge of administering legal and effectual justice. Else, when he has mistaken his authority through passion, through ignorance, or absurdity, he will be the object of contempt from his inferiors, and of censure from those to whom he is accountable for his conduct. Yet further, most gentlemen of considerable property, at some period or other in their lives, are ambitious of representing their country in Parliament, and those who are ambitious of receiving so high a trust would also do well to remember its nature and importance. They are not thus honorably distinguished from the rest of their fellow subjects, merely that they may privilege their persons, their estates, or their domestics, that they may list under party banners, may grant or withhold supplies, may vote with or vote against a popular or unpopular administration, but upon considerations far more interesting and important. They are the guardians of the English Constitution, the makers, repealers, and interpreters of the English laws, delegated to watch, to check, and to avert every dangerous innovation, to propose, to adopt, and to cherish any solid and well-weighted improvement, bound by every tie of nature, of honor, and of religion, to transmit that Constitution and those laws to their posterity, amended if possible, at least without any derogation. And how unbecoming must it appear in a member of the legislature to vote for a new law, who is utterly ignorant of the old? What kind of interpretation can he be enabled to give, who is a stranger to the text upon which he comments? Indeed, it is really amazing that there should be no other state of life, no other occupation, art, or science, in which some method of instruction is not looked upon as requisite, except only the science of legislation. The noblest and most difficult of any apprenticeships are held necessary to almost every art, commercial or mechanical. A long course of reading and study must form the divine, the physician, and the practical professor of the laws, but every man of superior fortune thinks himself born a legislator. Yet Tully was of a different opinion. "It is necessary," says he, "for a senator to be thoroughly acquainted with the Constitution, and this, he declares, is a knowledge of the most extensive nature, a matter of science, of diligence, of reflections, without which no senator can possibly be fit for his office. The mischiefs that have arisen to the public from inconsiderate alterations in our laws are too obvious to be called in question, and how far they have been owing to the defective education of our senators is a point well worthy the public attention. The common law of England has fared like other venerable edifices of antiquity, which rash and unexperienced workmen have ventured to new dress and refine, with all the rage of modern improvement. Hence frequently its symmetry has been destroyed, its proportions distorted, and its majestic simplicity exchanged for specious embellishments and fantastic novelties. For, to say the truth, almost all the perplexed questions, almost all the niceties, the intricacies, and delays, which have sometimes disgraced the English as well as other courts of justice, owe their original not to the common law itself, but to innovations that have been made in it by acts of Parliament, overladen, as Sir Edward Coke expresses it, with provisions and additions, and many times on a sudden, penned or corrected by men of none or very little judgment in law. This great and well-experienced judge declares that in all his time he never knew two questions made upon rights merely depending upon the common law, and warmly laments the confusion introduced by ill-judging and unlearned legislators. But if, he subjoins, acts of Parliament were after the old fashion pained by such only as perfectly knew what the common law was before the making of any act of Parliament concerning that matter, as also how far forth former statutes have provided remedy for former mischiefs, and defects discovered by experience, then should very few questions in law arise, and the learned should not so often and so much perplex their heads to make atonement and peace by construction of law between insensible and disagreeing words, sentences, and provisos, as they now do.
The construction of law, that's why what the Lord is talking about when he says precept upon precept and line upon line. This is how law is constructed. And new laws will arise as society expands. It's natural. So anyways, I love this stuff because this is all, this is really, common law is straight out of the Bible. Straight up, straight out of the Bible.
And if this inconvenience was so heavily felt in the reign of Queen Elizabeth, you may judge how the evil is increased in later times, when the statute book is swelled to 10 times a larger bulk, unless it should be found that the penners of our modern statutes have proportionally better informed themselves in the knowledge of the common law. What is said of our gentlemen in general?
And it is absolutely my position that the Bar Association this is why I call lawyers today bar cards. Because they're taught statutory law. They are not taught common law. And this is a huge fucking problem. This is why America's going down the tubes. Back under the Roman Empire you go. Hey, let's have fun with these inquisitions. This ought to be great. Oh, you're going to claim the Bible is, smarter than the Pope, are you? Yup. All day, every day.
And the propriety of their application to the study of the laws of their country will hold equally strong, or still stronger, with regard to the nobility of this realm, except only in the article of serving upon juries. But, instead of these, they have several peculiar provinces of far greater consequence and concern, being, not only by birth, hereditary counsellors of the crown.
And check this out. This is how they use, television to program your ass. Because, how many sitcoms and programs have they, taught people about, getting out of jury duty as though jury duty is a burden. You know what I mean? When it's actually like a very important function, and why a lot of people don't know about jury nullification that can get rid of all of these bullshit little laws that all of these little politicians keep, making through their acts and all of that. Passed a new act, another act for this bullshit play. So, filmed before a live studio audience. So anyway, this is why, this is how they plant those seeds of thought out into the, marketplace of ideas. And there's going to be a large percentage of people that'll buy that shit.
And judges upon their honor of the lives of their brother peers, but also arbiters of the property of all their fellow subjects, and that, in the last resort, in this their judicial capacity, they are bound to decide the nicest and most critical points of the law, to examine and correct such errors as have escaped the most experienced sages of the profession, the Lord Keeper and the judges of the courts at Westminster. Their sentence is final, decisive, irrevocable. No appeal, no correction, not even a review can be had. And to their determination, whatever it be, the inferior courts of justice must conform, otherwise the rule of property would no longer be uniform and steady. Should a judge in the most subordinate jurisdiction be deficient in the knowledge of the law, it would reflect infinite contempt upon himself and disgrace upon those who employ him. And yet, the consequence of his ignorance is comparatively very trifling and small. His judgment may be examined, and his errors rectified by other courts. But how much more serious and affecting is the case of a superior judge, if, without any skill in the laws he will boldly venture to decide a question upon which the welfare and subsistence of whole families may depend, where the chance of his judging right or wrong is barely equal, and where, if he chances to judge wrong, he does an injury of the most alarming nature, an injury without possibility of redress. Yet, vast as this trust is, it can nowhere be so properly reposed as in the noble hands where our excellent Constitution has placed it, and therefore placed it, because, from the independence of their fortune and the dignity of their station, they are presumed to employ that leisure which is the consequence of both, in attaining a more extensive knowledge of the laws than persons of inferior rank, and because the founders of our policy relied upon that delicacy of sentiment, so peculiar to noble birth, which, as on the one hand it will prevent either interest or affection from interfering in questions of right, so on the other it will bind the peer in honor, an obligation which the law esteems equal to another's oath, to be master of those points upon which it is his birthright to decide. The Roman Pandects will furnish us with a piece of history not unapplicable to our present purpose. Servius Sulpicius, a gentleman of the patrician order and a celebrated orator, had occasion to take the opinion of Quintus Mutius Scaevola, the oracle of the Roman law, but for want of some knowledge in that science, could not so much as understand even the technical terms, which his friend was obliged to make use of. Upon which Mutius Scaevola could not forbear to upbraid him with this memorable reproof, that it was a shame for a patrician, a nobleman and an orator of causes, to be ignorant of that law in which he was so peculiarly concerned. This reproach made so deep an impression on Sulpicius that he immediately applied himself to the study of the law, wherein he arrived to that proficiency, that he left behind him about 180 volumes of his own compiling upon the subject, and became, in the opinion of Cicero, a much more complete lawyer than even Mutius Scaevola himself. I would not be thought to recommend to our English nobility and gentry to become as great lawyers as Sulpicius, though he, together with his character, sustained likewise that of an excellent orator, a firm patriot, and a wise, indefatigable senator. But the inference which arises from this story is this, that ignorance of the law of the land hath ever been esteemed dishonorable in those who are entrusted by their country to maintain, to administer, and to amend them. But surely there is little occasion to enforce this argument any further to persons of rank and distinction, if we of this place may be allowed to form a general judgment from those who are under our inspection. Happy that while we lay down the rule, we can also produce the example. You will therefore permit your professor to indulge both a public and private satisfaction, by bearing this open testimony, that in the infancy of these studies among us, they were favored with the most diligent attendance, and pursued with the most unwearied application, by those of the noblest birth and most ample patrimony, some of whom are still the ornaments of this seat of learning, and others, at a greater distance, continue doing honor to its institutions, by comparing our policy and laws with those of other kingdoms abroad, or exerting their senatorial abilities in the councils of the nation at home. Nor will some degree of legal knowledge be found in the least superfluous to persons of inferior rank, especially those of the learned professions. The clergy in particular, besides the common obligations they are under in proportion to their rank and fortune, have also abundant reason, considered merely as clergymen, to be acquainted with many branches of the law, which are almost peculiar and appropriated to themselves alone. Such are the laws relating to advowsons, institutions, and inductions, to simony and simonical contracts, to uniformity, residence, and pluralities, to tithe and other ecclesiastical dues, to marriages, more especially of late, and to a variety of other subjects which are consigned to the care of their order by the provisions of particular statutes. To understand these aright, to discern what is warranted or enjoined, and what is forbidden by law, demands a sort of legal apprehension, which is no otherwise to be acquired than by use and a familiar acquaintance with legal writers. For the gentlemen of the faculty of physic, I must frankly own that I see no special reason why they in particular should apply themselves to the study of the law, unless in common with other gentlemen, and to complete the character of general and extensive knowledge, a character which their profession, beyond others, has remarkably deserved. They will give me leave, however, to suggest, and that not ludicrously, that it might frequently be of use to families upon sudden emergencies, if the physician were acquainted with the doctrine of last wills and testaments, at least so far as relates to the formal part of their execution.
The doctrine of last wills and testaments. The death of the testator. So, yep. God is a judge.
But those gentlemen who intend to process the civil and ecclesiastical laws in the spiritual and maritime courts of this kingdom are, of all men, next to the common lawyers, the most indispensably obliged to apply themselves seriously to the study of our municipal laws. For the civil and canon laws, considered with respect to any intrinsic obligation, have no force or authority in this kingdom. They are no more binding in England than our laws are binding at Rome. But as far as these foreign laws, on account of some peculiar propriety, have in some particular cases, and in some particular courts, been introduced and allowed by our laws, so far they oblige, and no farther, their authority being wholly founded upon that permission and adoption, in which we are no singular in our notions. For even in Holland, where the imperial law is much cultivated and its decisions pretty generally followed, we are informed by Van Leuven that it receives its force from customs and the consent of the people, either tacitly or expressly given. For otherwise, he adds, we should no more be bound by this law than by that of the Almains, the Franks, the Saxons, the Goths, the Vandals, and other of the ancient nations. Wherefore, in all points in which the different systems depart from each other, the law of the land takes place of the law of Rome, whether ancient or modern, imperial or pontifical. And in those of our English courts wherein a reception has been allowed to the civil.
Notice how they keep saying that, they're against the laws of Rome. And that is my position, is currently American law is sure looking a lot like old ancient Roman law when the Lord showed up.
And canon laws, if either they exceed the bounds of that reception by extending themselves to other matters than are permitted to them, or if such courts proceed according to the decisions of those laws, in cases wherein it is controlled by the law of the land, the common law in either instance both may, and frequently does, prohibit and annul their proceedings. And it will not be a sufficient excuse for them to tell the King's Courts at Westminster that their practice is warranted by the law of Justinian or Gregory, or is conformable to the decrees of the Rota or Imperial Chamber, for which reason it becomes highly necessary for every civilian and canonist that would act with safety as a judge, or with prudence and reputation as an advocate, to know in what cases and how far the English laws have given sanction to the Roman, in what points the latter are rejected, and where they are both so intermixed and blended together as to form certain supplemental parts of the common law of England, distinguished by the titles of the King's Maritime, the King's Military, and the King's Ecclesiastical Law, the propriety of which inquiry the University.
How many Americans today even know what ecclesiastical law is?
University of Oxford has for more than a century so thoroughly seen that in her statutes she appoints that one of the three questions to be annually discussed at the Act by the jurists and scepters shall relate to the common law, subjoining this reason: quia juris civilis studiosos desit baud imperitus esse juris municipalis, et differentias exterri patriique juris notas habere. And the statutes of the University of Cambridge speak expressly to the same effect. From the general use and necessity of some acquaintance with the common law, the inference were extremely easy, with regard to the propriety of the present institution, in the place to which gentlemen of all ranks and degrees resort, as the fountain of all useful knowledge. But how it has come to pass that a design of this sort has never before taken place in the University, and the reason why the study of our laws has in general fallen into disuse, I shall previously proceed to inquire. Sir John Fortescue, in his panegyric on the laws of England, which was written in the reign of Henry VI, puts a very obvious question in the mouth of the young prince, whom he is exhorting to apply himself to that branch of learning. Why the laws of England, being so good, so fruitful, and so commodious, are not taught in the universities, as the civil laws and canon laws are? In answer to which he gives, what seems, with due deference be it spoken, a very jejune and unsatisfactory reason, being, in short, that, as the proceedings at common law were in his time carried on 3 different tongues, the English, the Latin, and the French, that science must be necessarily taught in those 3 several languages, but that in the universities all sciences were taught in the Latin tongue only, and therefore he concludes that they could not be conveniently taught or studied in our universities. But, without attempting to examine seriously the validity of this reason, the very shadow of which, by the wisdom of your late constitutions, is entirely taken away, we perhaps may find out a better, or at least a more plausible account, why the study of the municipal laws has been banished from these seats of science, that what the learned Chancellor thought it prudent to give to his royal pupil, that ancient collection of unwritten maxims and customs, which is called the common law, however compounded or from whatever fountains derived, has subsisted immemorially in this kingdom, and, though somewhat altered and impaired by the violence of the times, had in great measure weathered the rude shock of the Norman conquest. This had endeared it to the people in general, as well because its decisions were universally known, as because it was found to be excellently adapted to the genius of the English nation. In the knowledge of this law consisted great part of the learning of those dark ages. It was then taught, says Mr. Selden, in the monasteries, in the universities, and in the families of the principal nobility. The clergy in particular, as they then engrossed almost every other branch of learning, so, like their predecessors the British Druids, they were peculiarly remarkable for their proficiency in the study of the law. Nullus clericus nisi causidicus is the character given of them soon after the conquest by William of Malmesbury. Clergy in particular, as they then engrossed almost every other branch of learning, so, like their predecessors the British Druids, they were peculiarly remarkable.
The clergy controlled education. Nothing new under the sun. That's why I'm saying we're in a Catholic education system.
For the proficiency in the study of the law. Nullus clericus nisi causidicus is the character given of them soon after the conquest by William of Malmesbury. The judges, therefore, were usually created out of the sacred order, as was likewise the case among the Normans, and all the inferior offices were supplied by the lower clergy, which has occasioned their successors to be denominated clerks to this day. But the common law of England, being not committed to writing, but only handed down by tradition, use, and experience, was not so heartily relished by the foreign clergy, who came over hither in shoals during the reign of the Conqueror and his 2 sons, and were utter strangers to our constitutions as well as our language. And an accident, which soon after happened, had nearly completed its ruin. A copy of Justinian's Pandects, being newly discovered at Amalfi, soon brought the civil law into vogue all over the west of Europe, where before it was quite laid aside, and in a manner forgotten. though some traces of its authority remained in Italy and in the eastern provinces of the empire. This now became in a particular manner the favorite of the popish clergy, who borrowed the method and many of the maxims of their canon law from the original. The study of it was introduced into several universities abroad, particularly that of Bologna, where exercises were performed, lectures read, and degrees conferred in this faculty, as in other branches of science. And many nations on the continent, just then beginning to recover from the convulsions consequent upon the overthrow of the Roman Empire, and settling by degrees into peaceable forms of government, adopted the civil law, being the best written system then extant, as the basis of their several constitutions, blending and interweaving it among their own feudal customs, in some places with a more extensive, in others a more confined authority. Nor was it long before the prevailing mode of the times reached England. For Theobald, a Norman abbot, being elected to the see of Canterbury, and extremely addicted to this new study, brought over with him in his retinue many learned proficients therein, and among the rest Roger surnamed Vicarius, whom he placed in the University of Oxford, to teach it to the people of this country. But it did not meet with the same easy reception in England, where a mild and rational system of laws had been long established, as it did upon the continent, and, though the monkish clergy, devoted to the will of a foreign primate, received it with eagerness and zeal, yet the laity, who were more interested to preserve the old constitution, and had already severely felt the effect of many Norman innovations, continued wedded to the use of the common law. King Stephen immediately published a proclamation forbidding the study of.
Just in case you didn't know, the Normans are responsible for the Magna Carta. Let me just double check. Are the Normans responsible for the Magna Carta? So it was the Normans. Well, whatever. They're the same peeps. Alright. How do I get back to that?
Of the laws, then newly imported from Italy, which was treated by the monks as a piece of impiety, and, though it might prevent the introduction of the civil law process into our courts of justice, yet did not hinder the clergy from reading and teaching it in their own schools and monasteries. From this time the nation seems to have been divided into two parties, the bishops and clergy, many of them foreigners, who applied themselves wholly to the study of the civil and canon laws, which now came to be inseparably interwoven with each other, and the nobility and laity, who adhered with equal pertinacy to the old common law, both of them reciprocally jealous of what they were unacquainted with, and neither of them perhaps allowing the opposite system that real merit which is abundantly to be found in each. This appears on the one hand from the spleen with which the monastic writers speak of our municipal laws upon all occasions, and, on the other, from the firm temper which the nobility shewed at the famous Parliament of Merton, when the prelates endeavoured to procure an act, to declare all bastards legitimate in case the parents intermarried at any time afterwards, alleging this only reason, because Holy Church, that is, the canon law, declared such children legitimate. But all the earls and barons, says the Parliament roll, with one voice answered that they would not change the laws of England, which had hitherto been used and approved. And we find the same jealousy prevailing above a century afterwards, when the nobility declared with a kind of prophetic spirit that the realm of England hath never been unto this hour, neither by consent of our Lord the King and the Lords of Parliament shall it ever be, ruled or governed by the civil law. And of this temper between the clergy and laity many more instances might be given. While things were in this situation, the clergy, finding it impossible to root out the municipal law, began to withdraw themselves by degrees from the temporal courts, and to that end, very early in the reign of King Henry III, episcopal constitutions were published, forbidding all ecclesiastics to appear as advocates in foro feculari, nor did they long continue to act as judges there, nor caring to take the oath of office which was then found necessary to be administered, that it should in all things determine according to the law and custom of this realm, though they still kept possession of the high office of Chancellor, an office then of little judicial power, and afterwards, as its business increased by degrees, they modelled the process of the court at their own discretion. But whenever they retired, and whenever their authority extended, they carried with them the same zeal to introduce the rules of the civil in exclusion of the municipal law. This appears in particular manner from the spiritual courts of all denominations, from the Chancellor's courts in both our universities, and from the High Court of Chancery before mentioned, in all of which the proceedings are to this day in a course much conformed to the civil law, for which no tolerable reason can be assigned, unless that these courts were all under the immediate direction of the popish ecclesiastics, among whom it was a point of religion to exclude the municipal law. Pope Innocent IV having forbidden the very reading of it by the clergy, because its decisions were not founded on the imperial constitutions, but merely on the customs of the laity. And if it be considered that our universities began about that period to receive their present form of scholastic discipline, that they were then, and continued to be, till the time of the Reformation, entirely under the influence of the popish clergy, Sir John Mason, the first Protestant, being also the first lay Chancellor of Oxford. This will lead us to perceive the reason why the study of the Roman laws was in those days of bigotry pursued with such alacrity in these seats of learning, and why the common law was entirely despised, and esteemed little better than heretical. And, since the Reformation, many causes have conspired to prevent its becoming a part of academical education, as, first, long usage and established custom, which, as in everything else, so especially in the forms of scholastic exercise, have justly great weight and authority. Secondly, the great intrinsic merit of the civil law, considered upon the footing of reason and not of obligation, which was well known to the instructors of our youth, and their total ignorance of the merit of the common law, though its equal at least, and perhaps an improvement on the other. But the principal reason of all that has hindered the introduction of this branch of learning is, that the study of the common law, being banished from hence in the times of popery, had fallen into a quite different channel, and has hitherto been wholly cultivated in another place. But, as this long usage and established custom of ignorance in the laws of the land begin now to be thought unreasonable, and as by this means the merit of those laws will probably be more generally known, we may hope that the method of studying them will soon revert to its ancient course, and the foundations, at least, of that science will be laid in the two universities, without being exclusively confined to the channel which it fell into at the times I have been just describing. For, being then entirely abandoned by the clergy, a few stragglers excepted, the study and practice of it devolved of course into the hands of laymen, who entertained upon their parts a most hearty aversion to the civil law, and made no scruple to profess their contempt, nay, even their ignorance of it, in the most public manner. But still, as the balance of learning was greatly on the side of the clergy, and as the common law was no longer taught, as formerly, in any part of the kingdom, it must have been subjected to many inconveniencies, and perhaps would have been gradually lost and overrun by the civil, a suspicion well justified from the frequent transcripts of Justinian to be met with in Bracton and Fleta, had it not been for a particular incident which happened at a very critical time, and contributed greatly to its support.
Introduction, Section 1, Part 3. The incident I mean was the fixing the Court of Common Pleas, the Grand Tribunal for Disputes of Property, to be held in one certain spot, that the seat of ordinary justice might be permanent and notorious to all the nation. Formerly that, in conjunction with all the other superior courts, was held before the King's Capital Justiciary of England in the Aula Regis, or such of his palaces wherein his royal person resided, and removed with his household from one end of the kingdom to the other. This was found to occasion great inconvenience to the suitors, to remedy which it was made an article of the Great Charter of Liberties, both that of King John and King Henry III, that common pleas should no longer follow the King's court, but be held in some certain place, in consequence of which they have ever since been held, a few necessary removals in times of the plague excepted, in the Palace of Westminster only. This brought together the professors of the municipal law, who before were dispersed about the kingdom, and formed them into an aggregate body, whereby a society was established of persons who, as Spellman observes, addicting themselves wholly to the study of the laws of the land, and no longer considering it as a mere subordinate science for the amusement of leisure hours, soon raised those laws to that pitch of perfection which they suddenly attained under the auspices of our English Justinian, King Edward I. In consequence of this lucky assemblage, they naturally fell into a kind of collegiate order, and, being excluded from Oxford and Cambridge, found it necessary to establish a new university of their own. This they did by purchasing at various times certain houses, now called the Inns of Court and of Chancery, between the city of Westminster, the place of holding the King's courts, and the city of London, for advantage of ready access to the one, and plenty of provisions in the other. Here exercises were performed, lectures read, and degrees were at length conferred in the common law, as at other universities in the canon and civil. The degrees were those of barristers, first styled apprentices from apprender to learn, who answered to our bachelors, as the state and degree of a sergeant, servientis ad legem, did to that of doctor. The Crown seems to have soon taken under its protection this infant seminary of common law, and the more effectually to foster and cherish it, King Henry III in the 19th year of his reign issued out an order directed to the mayor and sheriffs of London, commanding that no regent of any law schools within that city should for the future teach law therein. The word law, or leges, being a general term, may create some doubt at this distance of time whether the teaching of the civil law, or the common, or both, is hereby restrained. But in either case it tends to the same end. If the civil law only is prohibited, which is Mr. Selden's opinion, it is then a retaliation upon the clergy who had excluded the common law from their seats of learning. If the municipal law be also included in the restriction, as Sir Edward Coke understands it, and which the words seem to import, then the intention is evidently this: by preventing private teachers within the walls of the city to collect all the common lawyers into the one public university which was newly instituted in the suburbs. In this juridical university, for such it is insisted to have been by Fortescue and Sir Edward Coke, there are two sorts of collegiate houses, one called Inns of Chancery, in which the younger students of the law were usually placed, learning and studying, says Fortescue, the originals and, as it were, the elements of the law, who, profiting therein as they grow to ripeness, so are they admitted into the greater inns of the same study, called the Inns of Court. And in these inns of both kinds, he goes on to tell us, the knights and barons, with other grandees and noblemen of the realm, did use to place their children, though they did not desire to have them thoroughly learned in the law, or to get their living by its practice, and that in his time there were about 2,000 students at these several inns, all of whom, he informs us, were filii nobilium, or gentlemen born. Hence it is evident that, though under the influence of the monks our universities neglected this study yet, in the time of Henry VI it was thought highly necessary, and was the universal practice, for the young nobility and gentry to be instructed in the originals and elements of the laws.
Yet it seems to be missing from the American education system these days, for the young nobility and gentry. So yeah, it's my position, because of the tradition of the bar mitzvah. A 13-year-old boy is now held accountable to the law. You should start learning law, kid. Here's when we begin.
But by degrees this custom has fallen into disuse, so that in the reign of Queen Elizabeth Sir Edward Coke does not reckon above 1,000 students, and the number at present is very considerably less, which seems principally owing to these reasons. First, because the Inns of Chancery, being now almost totally filled by the inferior branch of the profession, they are neither commodious nor proper for the resort of gentlemen of any rank or figure, so that there are now very rarely any young students entered at the Inns of Chancery. Secondly, because in the Inns of Court all sorts of regimen and academical superintendents, either with regard to morals or studies, are found impracticable, and therefore entirely neglected. Lastly, because persons of birth and fortune, after having finished their usual courses at the universities, have seldom leisure or resolution sufficient to enter upon a new scheme of study at a new place of instruction. Wherefore few gentlemen now resort to the Inns of Court, but such for whom the knowledge of practice is absolutely necessary, such, I mean, as are intended for the profession. The rest of our gentry, not to say our nobility also, having usually retired to their estates, or visited foreign kingdoms, or entered upon public life without any instruction in the laws of the land, and indeed with hardly any opportunity of gaining instruction, unless it can be afforded them in these seats of learning. And that these are the proper places for affording assistances of this kind to gentlemen of all stations and degrees cannot, I think, with any colour of reason be denied. For not one of the objections which are made to the Inns of Court and Chancery, and which I have just enumerated, will hold with regard to the universities. Gentlemen may here associate with gentlemen of their own rank and degree, nor are their conduct and studies left entirely to their own discretion, but regulated by a discipline so wise and exact, yet so liberal, so sensible and manly, that their conformity to its rules, which does at present so much honour to our youth, is not more the effect of constraint than of their own inclinations and choice. Neither need they apprehend too long an avocation hereby from their private concerns and amusements, or, what is a more noble object, the service of their friends and their country. This study will go hand in hand with their other pursuits, It will obstruct none of them, it will ornament and assist them all. But if, upon the whole, there are any still wedded to monastic prejudice that can entertain a doubt how far this study is properly and regularly academical, such persons, I am afraid, either have not considered the constitution and design of an university, or else think very meanly of it. It must be a deplorable narrowness of mind that would confine these seats of instruction to the limited views of one or two learned professions. To the praise of this age be it spoken, a more open and generous way of thinking begins now universally to prevail. The attainment of liberal and genteel accomplishments, though not of the intellectual sort, has been thought by our wisest and most affectionate patrons, and very lately by the whole university, no small improvement of our ancient plan of education, and therefore I may safely affirm that nothing, how unusual soever, is, under due regulations, improper to be taught in this place which is proper for a gentleman to learn. But that a science which distinguishes the criterions of right and wrong, which teaches to establish the one and prevent, punish, or redress the other, which employs in its theory the noblest faculties of the soul and exerts in its practice the cardinal virtues of the heart, a science which is universal in its use and extent, accommodated to each individual, yet comprehending the whole community, that a science like this should have ever been deemed unnecessary to be studied in an university is matter of astonishment and concern. Surely, if it were not before an object of academical knowledge, it was high time to make it one. And to those who can doubt the propriety of its reception among us, if any such there be, we may return an answer in their own way, that ethics are confessedly a branch of academical learning, and Aristotle himself has said, speaking of the laws of his own country, that jurisprudence, or the knowledge of those laws, is the principal and most perfect branch of ethics. From a thorough conviction of this truth, our munificent benefactor, Mr. Viner, having employed above half a century in amassing materials for new modelling and rendering more commodious the rude study of the laws of the land, consigned both the plan and execution of these, his public-spirited designs, to the wisdom of his parent university. Resolving to dedicate his learned labours to the benefit of posterity and the perpetual service of his country, he was sensible he could not perform his resolutions in a better and more effectual manner than by extending to the youth of this place those assistances of which he so well remembered and so heartily regretted the want. And the sense which the university has entertained of this ample and most useful benefaction must appear beyond a doubt from their gratitude in receiving it with all possible marks of esteem, from their alacrity and unexampled dispatch in carrying it into execution, and, above all, from the laws and constitutions by which they have effectually guarded it from the neglect and abuse to which such institutions are liable. We have seen an universal emulation, who best should understand or most faithfully pursue the designs of our generous patron, and with pleasure we recollect that those who are most distinguished by their quality, their fortune, their station, their learning, or their experience, have appeared the most zealous to promote the success of Mr. Viner's establishment. End of section 3.
The advantages that might result to the science of the law itself, when a little more attended to in these seats of knowledge, perhaps would be very considerable. The leisure and abilities of the learned in these retirements might either suggest expedients, or execute those dictated by wiser heads, for improving its method, retrenching its superfluities, and reconciling the little contrarieties, which the practice of many centuries will necessarily create in any human system, a task which those who are deeply employed in business and the more active scenes of the profession can hardly condescend to engage in. And as to the interest, or which is the same, the reputation of the universities themselves, I may venture to pronounce that if ever this study should arrive to any tolerable perfection, either here or at Cambridge, the nobility and gentry of this kingdom would not shorten their residence upon this account, nor perhaps entertain a worse opinion of the benefits of academical education. Neither should it be considered as a matter of light importance that, while we thus extend the premieria of university learning, and adopt a new tribe of citizens within these philosophical walls, we interest a very numerous and very powerful profession in the preservation of our rights and revenues. For I think it is past dispute that those gentlemen who resort to the Inns of Court with a view to pursue the profession will find it expedient, whenever it is practicable, to lay the previous foundations of this, as well as every other science, in one of our learned universities. We may appeal to the experience of every sensible lawyer, whether anything can be more hazardous or discouraging than the usual entrance on the study of the law. A raw and unexperienced youth, in the most dangerous season of life, is transplanted on a sudden into the midst of allurements to pleasure, without any restraint or check but what his own prudence can suggest, with no public direction in what course to pursue his inquiries, no private assistance to remove the distresses and difficulties which will always embarrass a beginner. In this situation he is expected to sequester himself from the world, and by a tedious lonely process to extract the theory of law from a mass of undigested learning, or else by an assiduous attendance on the courts to pick up theory and practice together, sufficient to qualify him for the ordinary run of business. How little, therefore, is it to be wondered at that we hear of so frequent miscarriages, that so many gentlemen of bright imaginations grow weary of so unpromising a search, and addict themselves wholly to amusement, or other less innocent pursuits, and that so many persons of moderate capacity confuse themselves at first setting out, and continue ever dark and puzzled during the remainder of their lives. The evident want of some assistance in the rudiments of legal knowledge has given birth to a practice which, if ever it had grown to be general, must have proved of extremely pernicious consequence. I mean the custom, by some so very warmly recommended, to drop all liberal education, as of no use to lawyers, and to place them, in its stead, at the desk of some skilful attorney. In order to initiate them early in all the depths of practice, and render them more dexterous in the mechanical part of business. A few instances of particular persons, men of excellent learning and unblemished integrity, who in spite of this method of education have shone in the foremost ranks of the bar, have afforded some kind of sanction to this illiberal path to the profession, and biassed many parents of short-sighted judgment in its favour, not considering that there are some geniuses formed to overcome all disadvantages, and that from such particular instances no general rules can be formed, nor observing that those very persons have frequently recommended by the most forcible of all examples the disposal of their own offspring, a very different foundation of legal studies, a regular academical education. Perhaps, too, in return, I could now direct their eyes to our principal seats of justice, and suggest a few hints in favour of university learning. But in these, all who hear me, I know, have already prevented me. Many therefore due allowance for one or two shining exceptions. Experience may teach us to foretell that a lawyer thus educated to the bar, in subservience to attorneys and solicitors, will find he has begun at the wrong end. If practice be the whole he is taught, practice must also be the whole he will ever know, if he be uninstructed in the elements and first principles upon which the rules of practice is founded. The least variation from established precedents will totally distract and bewilder him. Ita lex scripta est is the utmost his knowledge will arrive at. He must never aspire to form, and seldom expect to comprehend, any arguments drawn a priori, from the spirit of the laws and the natural foundations of justice. Nor is this all, for, as few persons of birth or fortune, or even of scholastic education, will submit to the drudgery of servitude and the manual labor of copying the trash of an office. Should this infatuation prevail to any considerable degree, we must rarely expect to see a gentleman of distinction or learning at the bar, and what the consequence may be, to have the interpretation and enforcement of the laws, which include the entire disposal of our properties, liberties, and lives, fall wholly into the hands of obscure or illiberal men, is matter of very public concern. The inconveniences here pointed out can never be eventually.
Tell me he ain't perfectly describing the courts and Congress of America today. That right there. This is what you should be afraid of. A bunch of obscure or illiterate men, illiterate to law, that because all they know is statutory law, they know nothing of common law. Here we are today. Now our courts is a huge money maker. It's not about justice anymore.
Prevented, but by making academical education a previous step to the profession of the common law, and at the same time making the rudiments of the law a part of academical education. For sciences are of a sociable disposition, and flourish best in the neighborhood of each other. Nor is there any branch of learning but may be helped and improved by assistances drawn from other arts. If therefore the student in our laws hath formed both his sentiments and style, by perusal and imitation of the purest classical writers, among whom the historians and orators will best deserve his regard, if he can reason with precision, and separate argument from fallacy, by the clear simple rules of pure unsophisticated logic, if he can fix his attention, and steadily pursue truth through the most intricate deduction, by the use of mathematical demonstrations, if he has enlarged his conceptions of nature and art, by a view of the several branches of genuine experimental philosophy, if he has impressed on his mind the sound maxims of the law of nature, the best and most authentic foundation of human laws, if lastly he has contemplated those maxims reduced to a practical system in the laws of imperial Rome, if he has done this or any part of it, though all may be easily done under as able instructors as ever graced any seats of learning, a student thus qualified may enter upon the study of the law with incredible advantage and reputation. And if, at the conclusion, or during the acquisition of these accomplishments, he will afford himself here a year or two's farther leisure, to lay the foundation of his future labours in a solid scientifical method, without thrusting too early to attend that practice which it is impossible he should rightly comprehend, he will afterwards proceed with the greatest ease, and will unfold the most intricate points with an intuitive rapidity and clearness. I shall not insist upon such motives as might be drawn from principles of economy, and are applicable to particulars only. I reason upon more general topics, and therefore to the qualities of the head, which I have just enumerated. I cannot but add those of the heart, affectionate loyalty to the king, a zeal for liberty and the Constitution, a sense of real honor, and well-grounded principles of religion, as necessary to form a truly valuable English lawyer, a Hyde, a Hale, or a Talbot, and, whatever the ignorance of some, or unkindness of others, may have heretofore untruly suggested, experience will warrant us to affirm that these endowments of loyalty and public spirit, of honor and religion, are nowhere to be found in more high perfection than the 2 universities of this kingdom. Before I conclude, it may perhaps be expected that I lay before you a short and general account of the method I propose to follow, in endeavoring to execute the trust you have been pleased to repose in my hands. And in these solemn lectures, which are ordained to be read at the entrance of every term, more perhaps to the public honor of this laudable institution than for the private instruction of individuals, I presume it will best answer the intent of our benefactor and the expectation of this learned body, if I attempt to illustrate at times such detached titles of the law as are the most easy to be understood and most capable of historical or critical ornament. But in reading the complete course, which is annually consigned to my care, a more regular method will be necessary, and, till a better is proposed, I shall take the liberty to follow the same that I have already submitted to the public, to fill up and finish that outline with propriety and correctness, and to render the whole intelligible to the uninformed minds of beginners, whom we are too apt to suppose acquaintance with terms and ideas, which they never had opportunity to learn. This must be my ardent endeavor, though by no means my promise to accomplish. You will permit me, however, very briefly to describe, rather, what I conceive an academical expounder of the law should do, than what I have ever known to be done. He should consider his course as a general map of the law, marking out the shape of the country, its connections and boundaries, its greater divisions and principal cities. It is not his business to describe minutely the subordinate limits, or to fix the longitude and latitude of every inconsiderable hamlet. His attention should be engaged, like that of the readers in Fortescue's Inns of Chancery, in tracing out the originals, and as it were the elements of the law. For if, as Justinian has observed, the tender understanding of the student can be loaded at the first with a multitude and variety of matter, it will either occasion him to desert his studies, or will carry him heavily through them, with much labor, delay, and despondence. These originals should be traced to their fountains, as well as our distance will permit, to the customs of the Britons and Germans, as recorded by Caesar and Tacitus, to the codes of the northern nations on the continent, and more especially to those of our own Saxon princes, to the rules of the Roman law, either left here in the days of Papinian, or imported by Vicarius and his followers, but, above all, to that inexhaustible reservoir of legal antiquities and learning, the feudal law, or, as Spellman has entitled it, the law of nations in our western orb. These primary rules and fundamental principles should be weighed and compared with the precepts of the law of nature, and the practice of other countries, should be explained by reasons, illustrated by examples, and confirmed by undoubted authorities. Their history should be deduced, their changes and revolutions observed, and it should be shown how far they are connected with, or have at any time been affected by, the civil transactions of the kingdom. A plan of this nature, if executed with care and ability, cannot fail of administering a most useful and rational entertainment to students of all ranks and professions. And yet, it must be confessed that the study of the law is not merely a matter of amusement, for, as a very judicious writer has observed, upon a similar occasion, the learner will be considerably disappointed if he looks for entertainment without the expense of attention. An attention, however, no greater than is usually bestowed in mastering the rudiments of other sciences, or sometimes in pursuing a favorite recreation or exercise. And this attention is not equally necessary to be exerted by every student upon every occasion. Some branches of the law, as the formal process of civil suit, and the subtile distinctions incident to landed property, which are the most difficult to be thoroughly understood, are the least worth the pains of understanding, except to such gentlemen as intend to pursue the profession. To others, I may venture to apply, with a slight alteration, the words of Sir John Fortescue, when first his royal pupil determines to engage in this study. It will not be necessary for a gentleman, as such, to examine with a close application the critical niceties of the law. It will fully be sufficient, and he may well enough be denominated a lawyer, if under the instruction of a master he traces up the principles and grounds of the law, even to their original elements. Therefore, in a very short period, and with very little labour, he may be sufficiently informed in the laws of his country, if he will but apply his mind in good earnest to receive and apprehend them. For, though such knowledge as is necessary for a judge is hardly to be acquainted by the lucubrations of 20 years, yet with a genius of tolerable perspicacity, that knowledge which is fit for a person of birth or condition may be learned in a single year, without neglecting his other improvements. To the few, therefore, the very few, I am persuaded, that entertain such unworthy notions of an university, as to suppose it intended for mere dissipation of thought, to such as mean only to while away the awkward interval from childhood to 21, between the restraints of the school and the licentiousness of politer life, in a calm middle state of mental and of moral inactivity, to these Mr. Viner gives no invitation to an entertainment which they never can relish, but to the long and illustrious train of noble and ingenious youth, who are not more distinguished among us by their birth and possessions than by the regularity of their conduct and their thirst after useful knowledge. To these our benefactor has consecrated the fruits of a long and laborious life, worn out in the duties of his calling, and will joyfully reflect, if such reflections can be now the employment of his thoughts, that he could not more effectually have benefited posterity, or contributed to the service of the public, than by founding an institution which may instruct the rising generation in the wisdom of our civil policy, and inform them with a desire to be still better acquainted with the laws and constitution of their country.
All right, well, it's very, very good to be with you this morning, and I want to talk about creation.
Hold on, that ended quite abruptly. Hold on. Go back. It's just getting good. Sit there saying, yeah, man, this is, exactly when you start teaching kids that they're animals.
In order to initiate them
that evolved from a puddle of mud. That's when you get that's where you get the kind of society we live in today. Okay, wait. Let's go on this one.
Need a container? We've got over 2,000 in stock. Need it big, small, maybe glass, maybe not. Even if it's not on
Commentaries on the Laws of England by William Blackstone, Book 1, Introduction, Section 2, Part 1. Section the Second, of the Nature of Laws in General. Law, in its most general and comprehensive sense, signifies a rule of action, and is applied indiscriminately to all kinds of action, whether animate or inanimate, rational or irrational. Thus we say, the laws of motion, of gravitation, of optics or mechanics, as well as the laws of nature and of nations. And it is that rule of action which is prescribed by some superior, and which the inferior is bound to obey. Thus, when the Supreme Being formed the universe, and created matter out of nothing, he impressed certain principles upon that matter, from which it can never depart, and without which it would cease to be. When he put that matter into motion, he established certain laws of motion, to which all movable bodies must conform, and to descend from the greatest operation to the smallest. When a workman forms a clock, or other piece of mechanism, he establishes at his own pleasure certain arbitrary laws for its direction, as that the hand shall describe a given space in a given time, to which law, as long as the work conforms, so long it continues in perfection, and answers the end of its formation. If we further advance from mere inactive matter to vegetable and animal life, we shall find them still governed by laws, more numerous indeed, but equally fixed and invariable. The whole progress of plants, from the seed to the root, and from thence to the seed again, the method of animal nutrition, digestion, secretion, and all other branches of vital economy, are not left to chance or the will of the creature itself, but are performed in a wondrous involuntary manner, and guided by unerring rules laid down by the great Creator. This, then, is the general signification of law, a rule of action dedicated by some superior being, and in those creatures that have neither the power to think nor the will, such laws must be invariably obeyed, so long as the creature itself subsists, for its existence depends upon that obedience. But laws, in their more confined sense, and in which it is our present business to consider them, denote the rules, not of action in general, but of human action or conduct, that is, the precepts by which man, the noblest of all sublunary beings, a creature endowed with both reason and free will, is commanded to make use of those faculties in the general regulation of his behavior. Man, considered as a creature, must necessarily be subject to the laws of his Creator, for he is entirely a dependent being. A being, independent of any other, has no rule to pursue, but such as he prescribes to himself. But a state of dependence will inevitably oblige the inferior to take the will of him, on whom he depends, as the rule of his conduct.
That's important to note. See, this is a principle of law right here that's being used against us. This is what the Social Security system, you deserve it. Okay? A being independent of any other has no rule to pursue, but such as he prescribes to himself. That's why, when Smokey came at me with, is God bound to the law? Yeah, he bound himself to the law. Yeah, absolutely, he's bound to the law. But a state of dependence will inevitably oblige the inferior to take the will of him on whom he depends. This is why the government wants you dependent on them. This is a principle in nature that's being pointed out. So now you know, ain't nothing free about these benefits, baby. You know what I mean? Pay attention before you just accept benefits.
Indeed, in every particular, but in all those points wherein his dependence consists. This principle, therefore, has more or less extent and effect, in proportion as the superiority of the one and the dependence of the other is greater or less, absolute or limited, and consequently, as man depends absolutely upon his Maker for everything, it is necessary that he should in all points conform to his Maker's will. This will of his
Amen.
Maker is called
Tell me this is a great sermon already.
the law of nature. For as God, when he created matter, and endued it with a principle of mobility, established certain rules for the perpetual direction of that motion, so, when he created man, and endued him with free will to conduct himself in all parts of life, he laid down certain immutable laws of human nature, whereby that free will is in some degree regulated and restrained, and gave him also the faculty of reason to discover the purport of those laws. Considering the Creator only as a being of infinite power, he was able unquestionably to have prescribed whatever laws he pleased to his creature, man, however unjust or severe. But, as he is also a being of infinite wisdom, he has laid down only such laws as were founded in those relations of justice that existed in the nature of things antecedent to any positive precept. These are the eternal, immutable laws of good and evil, to which the Creator himself in all his dispensations conforms, and which he has enabled human reason to discover, so far as they are necessary for the conduct of human actions. Such, among others, are these principles: that we should live honestly, should hurt nobody, and should render to every one its due, to which three general precepts Justinian has reduced the whole doctrine of law. But if the discovery of these first principles of the law of nature depended only upon the due exertion of right reason, and could not otherwise be attained than by a chain of metaphysical disquisitions, mankind would have wanted some inducement to have quickened their inquiries, and the greater part of the world would have rested content in mental indolence, and ignorance its inseparable companion. As therefore the Creator is a being, not only of infinite power and wisdom, but also of infinite goodness, he has been pleased to contrive the constitution and frame of humanity, that we should want no other prompter to inquire after and pursue the rule of right, but only our own self-love, that universal principle of action. For he has so intimately connected, so inseparably interwoven the laws of eternal justice with the happiness of each individual, that the latter cannot be attained but by observing the former, and, if the former be punctually obeyed, it cannot but induce the latter. In consequence of which mutual connection of justice and human felicity, he has not perplexed the law of nature with a multitude of abstracted rules and precepts, referring merely to the fitness or unfitness of things, as some have vainly surmised, but has graciously reduced the rule of obedience to this one paternal precept, that man should pursue his own happiness. This is the foundation of what we call ethics, or natural law.
Man, that almost puts a lump in my throat right there. See, it is God that wills for you to be free. Why would you want any other God? Why are you shopping around? Why are you rebelling against the God of the Bible? that wants you to know him and be aware and be wise, not be dumb and ignorant and in darkness. You know what I mean? Vote for Jesus. No.
For the several articles into which it is branched in our own systems amount to no more than demonstrating that this or that action tends to a man's real happiness, and therefore very justly concluding that the performance of it is a part of the law of nature, or, on the other hand, that this or that action is destructive of man's real happiness, and therefore that the law of nature forbids. This law of nature,
I mean, isn't that pretty much what Solomon said in Ecclesiastes at the end of his life? Man, I wish I would have just obeyed God. I'm so stupid. I should have just listened. I should have just done what he told me to do. It's the only time I was ever happy. All is vanity.
being coeval with mankind and dedicated by God himself, is of course superior in obligation to any other. It is binding all over the globe, in all countries, and at all times. No human laws are of any validity if contrary to this.
Ooh, I love that. That should be the Christian motto right there. No human laws are of any validity if contrary to this. If they're contrary to God's laws, they are not valid. That is how this country needs to be run. That's reality. Instead of this money-making judicial system scheme of a bunch of clowns that do not honor their oath to our Constitution. If you don't honor your oath, you are not in a position to be a judge, period.
And such of them as are valid derive all their force and all their authority, immediately or immediately, from this original. But in order to apply this to the particular exigencies of each individual, it is still necessary to have recourse to reason, whose office it is to discover, as was before observed, what the law of nature directs in every circumstance of life, by considering what method will tend to most effectually to our own substantial happiness. And if our reason were always, as in our first ancestor before his transgression, clear and perfect, unruffled by passions, unclouded by prejudice, unimpaired by disease or intemperance, the task would be pleasant and easy. We should need no other guide but this. But every man now finds the contrary in his own experience, that his reason is corrupt, and his understanding full of ignorance and error. This has given manifold occasion for the benign interposition of divine providence, which, in companion to the frailty, the imperfection, and the blindness of human reason, hath been pleased, at sundry times and in divers manners, to discover and enforce its laws by an immediate and direct revelation. The doctrines thus delivered we call the revealed or divine law, and they are to be found only in the Holy Scriptures. These precepts, when revealed, are found upon comparison to be really a part of the original law of nature, as they tend in all their consequences to man's felicity. But we are not from thence to conclude that the knowledge of these truths was attainable by reason, in its present corrupted state, since we find that, until they were revealed, they were hid from the wisdom of ages. As then, the moral precepts of this law are indeed the same original with those of the law of nature, so their intrinsic obligation is of equal strength and perpetuity. Yet undoubtedly the revealed law is, humanly speaking, of infinitely more authority than what we generally call the natural law, because one is the law of nature, expressly declared so to be by God himself. The other is only what, by the assistance of human reason, we imagine to be that law. If we could be as certain of the latter as we are of the former, both would have an equal authority. But till then, they can never be put in any competition together. Upon these two foundations, the law of nature and the law of revelation, depend all human laws. That is to say, no human laws should be suffered to contradict these. There is, it is true, a great number of indifferent points, in which both the divine and the natural leave a man at his own liberty, but which are found necessary for the benefit of society to be restrained within certain limits. And herein it is that human laws have their greatest force and efficacy. For, with regard to such points as are not indifferent, human laws are only declaratory of, and act in subordination to, the former. To instance, in the case of murder, this is expressly forbidden by the divine, and demonstrably by the natural law, and from these prohibitions arises the true unlawfulness of this crime. Those human laws that annex a punishment to it do not at all increase its moral guilt, or superadd any fresh obligation in foro conscientiae to abstain from its perpetration. Nay, if any human law should allow or enjoin us to commit it, we are bound to transgress that human law, or else we must offend both the natural.
Just like the, handmaidens of the pharaohs when they refused to kill the little babies. God honored them ladies.
And the divine. But with regard to matters that are in themselves indifferent, and are not commended or forbidden by those superior laws, such for instance as exporting of wool into foreign countries, here the inferior legislature has scope and opportunity to interpose and to make that action unlawful, which before was not so. If man were to live in a state of nature, unconnected with other individuals, there would be no occasion for any other laws than the law of nature and the law of God. Neither could any other law possibly exist, for a law always supposes some superior who is to make it, and in a state of nature we are all equal, without any other superior but him who is the author of our being. But man was formed for society, and, as is demonstrated by the writers on this subject, is neither capable of living alone, nor indeed has the courage to do it. However, as it is impossible for the whole race of mankind to be united in one great society, they must necessarily divide into many, and form separate states, commonwealths, and nations, entirely independent of each other, and yet liable to a mutual intercourse. Hence arises a third kind of law to regulate this mutual intercourse, called the law of nations, which, as none of these states will acknowledge a superiority in the other, cannot be dictated by either, but depends entirely upon the rules of natural law, or upon mutual compacts, treaties, leagues, and agreements between these several communities, in the construction also of which compacts we have no other rule to resort to but the law of nature, being the only one to which both communities are equally subject. And therefore the civil law very justly observed that quod naturalis ratio inter omnes homines constituit, vocatur ius gentium. Thus much I thought it necessary to premise concerning the law of nature, the revealed law, and the law of nations, before I proceed to treat more fully of the principal subject of this section, municipal or civil law, that is, the rule by which particular districts, communities, or nations are governed. being thus defined by Justinian, Jus civile est quod quisque sibi populus constituit. I call it municipal law, in compliance with common speech, for, though strictly that expression denotes the particular customs of one single municipium, or free town, yet it may be sufficient propriety to be applied in any one state or nation which is governed by the same laws and customs. Municipal law, thus understood, is properly defined to be a rule of civil conduct prescribed by the supreme power in a state, commanding what is right, and prohibiting what is wrong. Let us endeavor to explain its several properties, as they arise out of this definition. And first, it is a rule, not a transient sudden order from a superior to, or concerning a particular person, but something permanent, uniform, and universal. Therefore, a particular act of the legislature to confiscate the goods of Titius, or to attain him of high treason, does not enter into the idea of a municipal law, for the operation of this act is spent upon Titius only, and has no relation to the community in general. It is rather a sentence than a law, but an act to declare that the crime of which Titius is accused shall be deemed high treason. This has permanency, uniformity, and universality, and therefore is properly a rule. It is also called a rule, to distinguish it from advice or counsel, which we are at liberty to follow or not, as we see proper, and to judge upon the reasonableness or unreasonableness of the thing advised. Whereas our obedience to the law depends not only upon our approbation, but upon the Maker's will.
Hello everyone. Today we're taking a closer look at a 1.5 megawatt/3 megawatt.
Counsel is only matter of persuasion. Law is matter of injunction. Counsel acts only upon the willing. Law upon the unwilling also. It is also called a rule, to distinguish it from a compact or agreement, for a compact is a promise proceeding from us, law is a command directed to us. The language of a compact is, I will, or will not, do this. That of a law is, thou shalt, or shalt not, do it. It is true, there is an obligation which a compact carries with it, equal in point of conscience to that of a law. But then the original of the obligation is different. In compacts, we ourselves determine and promise what shall be done. Therefore, we are obliged to do it. In laws, we are obliged to act, without ourselves determining or promising anything at all. Upon these accounts, law is defined to be a rule. Municipal law is also a rule of civil conduct. This distinguishes municipal law from the natural or revealed, the former of which is the rule of moral conduct, and the latter not only the rule of moral conduct, but also the rule of faith. These regard man as a creature, and point out his duty to God, to himself, and to his neighbor, considered in the light of an individual. But municipal or civil law regards him also as a citizen, and bound to other duties towards his neighbor than those of mere nature and religion, duties which he has engaged in by enjoying the benefits of the common union, and which amount to no more than that he do contribute, on his part, to the subsistence and peace of the society. It is likewise a rule prescribed, because a bare resolution, confined in the breast of the legislator, without manifesting itself by some external sign, can never be properly a law. It is requisite that this resolution be notified to the people who are to obey it, But the manner in which this notification is to be made is matter of very great indifference. It may be notified by universal tradition and long practice, which supposes a previous publication, and is the case of the common law of England. It may be notified viva voce by officers appointed for that purpose, as is done with regard to proclamations, and such acts of Parliament are appointed to be publicly read in churches and other assemblies. It may lastly be notified by writing, printing, or the like, which is the general course taken with all our acts of Parliament. Yet, whatever way is made use of, it is incumbent on the promulgators to do it in the most public and perspicuous manner, not like Caligula, who, according to Dio Cassius, wrote his laws in a very small character, and hung them up upon high pillars, the more effectually to ensnare the people. There is still a more unreasonable method than this, which is called making of laws ex post facto, when, after an action is committed, the legislator then for the first time declares it to have been a crime, and inflicts a punishment upon the person who has committed it. Here it is impossible that a party could foresee that an action, innocent when it was done, should be afterwards converted to guilt by a subsequent law. He had therefore no cause to abstain from it, and all punishment for not abstaining must of consequence be cruel and unjust. All laws should be therefore made to commence in futuro, and be notified before their commencement, which is implied in the term prescribed. But when this rule is in the usual manner notified or prescribed, it is then the subject's business to be thoroughly acquainted therewith. For if ignorance of what he might know were admitted as a legitimate excuse, the laws would be of no effect, but might always be eluded with impunity. But further, municipal law is a rule of civil conduct prescribed by the supreme power in a state. For a legislature, as was before observed, it is the greatest act of superiority that can be exercised by one being over another. Wherefore it is requisite to the very essence of the law that it be made by the supreme power. Sovereignty and legislature are indeed convertible terms. One cannot subsist without the other. This will naturally lead us into a short inquiry concerning the nature of society and civil government, and the natural, inherent right that belongs to the sovereignty of a state, wherever that sovereignty be lodged, of making and enforcing laws. The only true and natural foundations of society are the wants and the fears of individuals. Not that we can believe, with some theoretical writers, that there ever was a time when there was no such thing as society, and that, from the impulse of reason, and through a sense of their wants and weaknesses, individuals met together in a large plain, entered into an original contract, and chose the tallest man present to be their governor. This notion of an actually existing unconnected state of nature is too wild to be seriously admitted, and besides, it is plainly contradictory to the revealed accounts of the primitive origin of mankind, and their preservation 2000 years afterwards, both which were effected by the means of single families. These formed the first society, among themselves, which every day extended its limits, and when it grew too large to subsist with convenience in that pastoral state wherein the patriarchs appear to have lived, it necessarily subdivided itself by various migrations into more. Afterwards, as agriculture increased, which employs and can maintain a much greater number of hands, migrations became less frequent, and various tribes, which had formerly separated, reunited again, sometimes by compulsion and conquest, sometimes by accident, and sometimes perhaps by compact. But though society had not its formal beginning from any convention of individuals, actuated by their wants and their fears, yet it is the sense of their weakness and imperfection that keeps mankind together. That demonstrates the necessity of this union, and that therefore is the solid and natural foundation, as well as the cement of society. And this is what we mean by the original contract of society, which, though perhaps in no instance it has ever been formally expressed, at the first institution of a state, yet in nature and reason must always be understood and implied, in the very act of associating together, namely, that the whole should protect all its parts, and that every part should pay obedience to the will of the whole, or, in other words, that the community should guard the rights of each individual member, and that, in return for this protection, each individual.
But yeah, somehow in our society we've adopted this idea of, it's not none of my business. I don't want to get involved. Well, every time you don't get involved, we just lost, we just lost yardage, and the government gained yardage.
Should submit to the laws of the community, without which submission of all it was impossible that protection could be certainly extended to any. For when society is once formed, government results of course, as necessary to preserve and to keep that society in order, unless some superior were constituted, whose commands and decisions all members are bound to obey, they would still remain as in a state of nature, without any judge upon earth to define their several rights, and redress their several wrongs. But, as all the members of society are naturally equal, it may be asked, in whose hands are the reins of government to be entrusted? To this, the general answer is easy.
There was debris floating around the spacecraft.
There was a whole bunch of particles.
But the application of it to particular cases has occasioned one half of those mischiefs which are apt to proceed from misguided political zeal. In general, all mankind will agree that government should be reposed in such persons, in whom those qualities are most likely to be found, the perfection of which are among the attributes of him who is emphatically styled the Supreme Being. The three grand requisites, I mean, of wisdom, of goodness, and of power. Wisdom, to discern the real interest of the community. Goodness, to endeavor always to pursue that real interest. And strength, or power, to carry this knowledge and intention into action. These are the natural foundations of sovereignty, and these are the requisites that ought to be found in every well-constituted frame of government. How the several forms of government we now see in the world at first actually began, is a matter of great uncertainty, and has occasioned infinite disputes. It is not my business or intention to enter into any of them. However they began, or by what right soever they subsist, there is, and must be, in all of them, a supreme, irresistible, absolute, uncontrolled authority, in which the jura summi imperii, or the rights of sovereignty, reside. And this authority is placed in those hands, wherein, according to the opinion of the founders of such respective states, either expressly given, or collected from their tacit approbation, the qualities requisite for supremacy, wisdom, goodness, and power, are the most likely to be found. The political writers of antiquity will not allow more than three regular forms of government. The first, when the sovereign power is lodged in an aggregate assembly consisting of all the members of a community, which is called a democracy. The second, when it is lodged in a council, composed of select members, and then it is styled an aristocracy. The last, when it is entrusted in the hands of a single person, then it takes the name of a monarchy. All other species of government, they say, are either corruptions of, or reducible to, these three. By the sovereign power, as was before observed, is meant the making of laws. For wherever that power resides, all others must conform to, and be directed by it, whatever appearance the outward form and administration of the government may put on. For it is at any time in the option of the legislature to alter that form and administration by a new edict or rule, and to put the execution of the laws into whatever hands it pleases. And all the other powers of the state must obey the legislative power in the execution of their several functions, or else the constitution is at an end. In a democracy, where the right of making laws resides in the people at large, public virtue, or goodness of intention, is more likely to be found than either of the other qualities of government. Popular assemblies are frequently foolish in their contrivance, and weak in their execution, but generally mean to do the thing that is right and just, and have always a degree of patriotism or public spirit. In aristocracies, there is more wisdom to be found than in the other frames of government, being composed, or intended to be composed, of the most experienced citizens. But there is less honesty in a republic, and less strength than in a monarchy. A monarchy is indeed the most powerful of any, all the sinews of government being knit together and united in the hand of the prince. But then there is an imminent danger of his employing that strength to improvident or oppressive purposes. Thus these three species of government have, all of them, their several perfections and imperfections. Democracies are usually the best calculated to direct the end of a law; aristocracies, to invent the means by which that end shall be obtained; and monarchies, to carry those means into execution. And the ancients, as was observed, had in general no idea of any other permanent form of government but these three. For though Cicero declares himself of opinion, esse optime constitutatem republicam, quae ex tribus generibus illis regali optimo et populari sit modite confusa, yet Tacitus treats this notion of a mixed government, formed out of them all, and partaking of the advantages of each, as a visionary whim, and one that, if effected, could never be lasting or secure. But happily for us of this island, the British Constitution has long remained, and I trust will long continue, a standing exception to the truth of this observation. For, as with us, the executive power of the laws is lodged in a single person, they have all the advantages of strength and dispatch that are to be found in the most absolute monarchy, and, as the legislature of the kingdom is entrusted to three distinct powers, entirely independent of each other, first, the king; secondly, the lords spiritual and temporal, which is an aristocratical assembly of persons selected for their piety, their birth, their wisdom, their valor, or their property; and thirdly, the House of Commons, freely chosen by the people from among themselves, which makes it a kind of democracy. As this aggregate body, actuated by different springs, and attentive to different interests, composes the British Parliament, and has the supreme disposal of everything, there can no inconvenience be attempted by either of the three branches, but will be withstood by one of the other two, each branch being armed with a negative power, sufficient to repel any innovation which it shall think inexpedient or dangerous. Here then is lodged the sovereignty of the British Constitution, and lodged as beneficially as possible for society, for in no other shape could we be so certain of finding the three great qualities of government so well and so happily united. If the supreme power were lodged in any one of the three branches separately, we must be exposed to the inconveniencies of either absolute monarchy, aristocracy, or democracy, and so want two of the three principal ingredients of good policy, either virtue, wisdom, or power. If it were lodged in any two of the branches, for instance, in the King and House of Lords, our laws might be providently made and well executed, but they might not always have the good of the people in view. If lodged in the King and Commons, we should want that circumspection and mediatory caution which the wisdom of the peers is to afford. If the supreme rights of legislature were lodged in the two houses only, and the king had no negative upon their proceedings, they might be tempted to encroach upon the royal prerogative, or perhaps to abolish the kingly office, and thereby weaken, if not totally destroy, the strength of the executive power. But the constitutional government of this island is so admirably tempered and compounded that nothing can endanger or hurt it, but destroying the equilibrium of power between one branch of the legislature and the rest. For if ever it should happen that the independence of any one of the three should be lost, or that it should become subservient to the views of either of the other two, there would soon be an end to our Constitution. The legislature would be changed from that which was originally set up by the general consent and fundamental act of the society. And such a change, however effected, is, according to Mr. Locke, who perhaps carries his theory too far, at once an entire dissolution of the bands of government, and the people will be reduced to a state of anarchy, with liberty to constitute to themselves a new legislative power. Having thus cursorily considered the three usual species of government, and our own singular constitution, selected and compounded from them all, I proceed to observe that, as the power of making laws constitutes the supreme authority, so wherever the supreme authority in any state resides, it is the right of that authority to make laws, that is, in the words of our definition, to prescribe the rule of civil action. And this may be discovered from the very end and institution of civil states. For a state is a collective body, composed of a multitude of individuals, united for their safety and convenience, and intending to act together as one man. If it therefore is to act as one man, it ought to act by one uniform will. But, inasmuch as political communities are made up of many natural persons, each of whom has his particular will and inclination, these several wills cannot by any natural union be joined together, or tempered and disposed into a lasting harmony, so as to constitute and produce that one uniform will of the whole. It can therefore be no otherwise produced than by a political union, by the consent of all persons to submit to their own private wills to the will of one man, or of one or more assemblies of men, to whom the supreme authority is entrusted, and this will of that one man, or assemblage of men, is in different states, according to their different constitutions, understood to be law. Thus far as to the right of the supreme power to make laws, but further, it is its duty likewise. For since the respective members are bound to conform themselves to the will of the state, it is expedient that they receive directions from the state declaratory of that its will. But since it is impossible, in so great a multitude, to give injunctions to every particular man, relative to each particular action, therefore the state establishes general rules for the perpetual information and direction of all persons in all points, whether of positive or negative duty. And this, in order that every man may know what to look upon as his own, what as another's, what absolute and what relative duties are required at his hands, what is to be esteemed honest, dishonest, or indifferent, what degree every man retains of his natural liberty, what he has given up as the price of the benefits of society, and after what manner each person is to moderate the use and exercise of those rights which the state assigns him, in order to promote and secure the public tranquillity. From what has been advanced, the truth of the former branch of our definition is, I trust, sufficiently evident, that municipal law is a rule of civil conduct prescribed by the supreme power in a state. I proceed now to the latter branch of it, that it is a rule so prescribed, commanding what is right, and prohibiting what is wrong. Now, in order to do this completely, it is first of all necessary that the boundaries of right and wrong be established and ascertained by law, and when this is once done, it will follow of course that it is likewise the business of the law, considered as a rule of civil conduct, to enforce these rights and to restrain or redress these wrongs. It remains therefore only to consider in what manner the law is said to ascertain the boundaries of right and wrong, and the methods which it takes to command the one and prohibit the other. For this purpose every law may be said to consist of several parts: 1. Declaratory, whereby the rights to be observed and the wrongs to be eschewed are clearly defined and laid down. Another, directory, whereby the subject is instructed and enjoined to observe those rights and to abstain from the commission of those wrongs. A third, remedial, whereby a method is pointed out to recover a man's private rights, or redress his private wrongs, to which may be added a fourth, usually termed the sanction or vindicatory branch of the law, whereby it is signified that evil or penalty shall be incurred by such as commit any public wrongs and transgress or neglect their duty. With regard to the first of these, the declaratory part of the municipal law, this depends not so much upon the law of revelation or of nature as upon the wisdom and will of the legislator. This doctrine, which before was slightly touched, deserves a more particular explication. Those rights than which God and nature have established, and are therefore called natural rights, such as are life and liberty, need not the aid of human laws to be more effectually inverted in every man than they are. Neither do they receive any additional strength when declared by the municipal laws to be inviolable. On the contrary, no human legislature has power to abridge or destroy them, unless the owner shall himself commit some act that amounts to a forfeiture. Neither do divine or natural duties, such as for instance the worship of God, the maintenance of children, and the like, receive any stronger sanction from being also declared to be duties by the law of the land. The case is the same as to crimes and misdemeanors that are forbidden by the superior laws, and therefore styled mala in se, such as murder, theft, and perjury, which contract no additional turpitude, from being declared unlawful by the inferior legislature. For that legislature in all these cases acts only, as was before observed, in subordination to the great lawgiver, transcribing and publishing his precepts, so that, upon the whole, the declaratory part of the municipal law has no force or operation at all, with regard to actions that are naturally and intrinsically right or wrong. But, with regard to things in themselves indifferent, the case is entirely altered. These become either right or wrong, just or unjust, duties or misdemeanors, according as the municipal legislator sees proper, for promoting the welfare of the society, and more effectually carrying on the purposes of civil life. Thus, our own common law has declared that the goods of the wife do instantly upon marriage become the property and right of the husband, and our statute law has declared all monopolies a public offense. Yet that right and this offense have no foundation in nature, but are merely created by the law, for the purposes of civil society. And sometimes, where the thing itself has its rise from the law of nature, the particular circumstance and mode of doing it become right or wrong, as the laws of the land shall direct. Thus, for instance, in civil duties, obedience to superiors is the doctrine of revealed as well as natural religion. But who those superiors shall be, and in what circumstances, or to what degrees they shall be obeyed, is the province of human laws to determine. And so, as to injuries or crimes, it must be left to our own legislature to decide in what cases the seizing of another's cattle shall amount to the crime of robbery, and where it shall be a justifiable action, as when a landlord takes them by way of distress for rent. Thus much for the declaratory part of the municipal law, and the directory stands much upon the same footing. For this virtually includes the former, the declaration being usually collected from the direction. The law that says, "Thou shalt not steal," implies a declaration that stealing is a crime. And we have seen that, in things naturally indifferent, the very essence of right and wrong depend upon the direction of the laws to do or to omit it. The remedial part of a law is so necessary a consequence of the former two, that laws must be very vague and imperfect without it. For in vain would rights be declared, in vain directed to be observed, if there were no method of recovering and asserting those rights, when wrongfully withheld or invaded. This is what we mean, properly, when we speak of the protection of the law, when, for instance, the declaratory part of the law has said that the field or inheritance which belonged to Titius's father is vested by his death in Titius, and the directory part has forbidden any one to enter on another's property without the leave of the owner. If Gaius after this will presume to take possession of the land, the remedial part of the law will then interpose its office, will make Gaius restore the possession to Titius, and also pay him damages for the invasion. With regard to the sanction of laws, or the evil that may attend the breach of public duties, it is observed that human legislators have for the most part chosen to make the sanction of their laws rather vindicatory than remuneratory, or to consist rather in punishments than in actual particular rewards, because in the first part the quiet enjoyment and protection for all our civil rights and liberties, which are the sure and general consequence of obedience to the municipal law, are in themselves the best and most valuable of all rewards. Because also, were the exercise of every virtue to be enforced by the proposal of particular rewards, it were impossible for any state to furnish stock enough for so profuse a bounty. And further, because the dread of evil is a much more forcible principle of human actions than the prospect of good. For which reasons, though a prudent bestowing of rewards is sometimes of exquisite use, yet we find that those civil laws which enforce and enjoin our duty do seldom, if ever, propose any privilege or gift to such as obey the law, but do constantly come armed with a penalty denounced against transgressors, either expressly defining the nature and quantity of the punishment, or else leaving it to the discretion of the judges, and those who are entrusted with the care of putting the law in execution. Of all the parts of a law, the most effectual is the vindicatory, for it is but lost labor to say, do this, or avoid that, unless we also declare, this shall be the consequence of your non-compliance. We must therefore observe that the main strength and force of a law consists in the penalty annexed to it. Herein is to be found the principal obligation of human laws. End of section 6. Legislators and their laws are said to compel and oblige. Not that by any natural violence they so constrain a man as to render it impossible for him to act otherwise than as they direct, which is the strict sense of obligation, but because, by declaring and exhibiting a penalty against offenders, they bring it to pass that no man can easily choose to transgress the law, since, by reason of impending correction, compliance is in a high degree preferable to disobedience, and, even where rewards are proposed as well as punishments threatened, the obligation of the law seems chiefly to consist in the penalty, for rewards, in their nature, can only persuade and allure. Nothing is compulsory but punishment. It is held, it is true, and very justly, by the principle of our ethical writers, that human laws are binding upon men's consciences. But if that were the only, or most forcible obligation, the good only would regard the law, and the bad would set them at defiance. And, true as this principle is, it must still be understood with some restriction. It holds, I apprehend, as to rights, and that, when the law has determined the field to belong to Titius, it is matter of conscience no longer to withhold or to invade it. So also in regard to natural duties, and such offences as are mala in se. Here we are bound in conscience, because we are bound by superior laws, before those human laws were in being, to perform the one and abstain from the other. But in revelation to those laws which enjoin only positive duties, and forbid only such things as are not mala in se, but mala prohibita, merely annexing a penalty to non-compliance, here I apprehend conscience is no further concerned than by directing a submission to the penalty, in case of our breach of those laws, for otherwise the multitude of penal laws in a state would not only be looked upon as an impolitic, but would also be a very wicked thing, if every such law were a snare for the conscience of the subject. But in these cases, the alternative is offered to every man: either abstain from this, or submit to such a penalty, and his conscience will be clear, whichever side of the alternative he thinks proper to embrace. Thus, by the statutes for preserving the game, a penalty is denounced against every unqualified person that kills a hare. Now this prohibitory law does not make the transgression a moral offense. The only obligation in conscience is to submit to the penalty if levied. have now gone through the definition laid down of a municipal law, and have shown it that it is a rule of conduct prescribed by the supreme power in a state, commanding what is right and prohibiting what is wrong, in the explication of which I have endeavored to interweave a few useful principles concerning the nature of civil government and the obligation of human laws. Before I conclude this section, it may not be amiss to add a few observations concerning the interpretation of laws. When any doubt arose upon the construction of the Roman laws, the usage was to state the case to the emperor in writing, and take his opinion upon it. This was certainly a bad method of interpretation. To interrogate the legislature to decide particular disputes is not only endless, but affords great room for partiality and oppression. The answers of the emperor were called his rescripts, and these had in succeeding cases the force of perpetual laws, though they ought to be carefully distinguished by every rational civilian from those general constitutions which had only the nature of things for their guide. The Emperor Macrinius and his historian Capitolinus informs us, had once resolved to abolish these rescripts, and retain only the general edicts. He could not bear that the hasty and crude answers of such princes as Commodus and Caracalla should be reverenced as laws. But Justinian thought otherwise, and he has preserved them all. In like manner, the canon laws, or decretal epistles of the popes, are all of them rescripts in the strictest sense. Contrary to all true forms of reasoning, they argue from particulars to generals. The fairest and most rational method to interpret the will of the legislator is by exploring his intentions at the time when the law was made, by signs the most natural and probable, and these signs are either the words, the context, the subject matter, the effects and consequence, or the spirit and reason of the law. Let us take a short view of them all. 1. Words are generally to be understood in their usual and most known signification, not so much regarding the propriety of grammar as their general and popular use. Thus, the law mentioned by Pufendorf, which forbade a layman to lay hands on a priest, was adjudged to extend to him who had hurt a priest with a weapon. Again, terms of art, or technical terms, must be taken according to the acceptation of the learned in each art, trade, and science. So in the Act of Settlement, where the crown of England is limited to the Princess Sophia and the heirs of her body, being Protestants, it becomes necessary to call in the assistance of lawyers to ascertain the precise idea of the words heirs of her body, which in a legal sense comprise only certain of her lineal descendants. Lastly, where words are clearly repugnant in two laws, the later shall take place of the elder. Leges posteriores priores contrarias abrogant is a maxim of universal law, as well as our own constitutions, and accordingly it was laid down by a law of the 12 tables at Rome. Quod populus postremum iusit, id ius ratum esto. 2. If words happen to be still dubious, we may establish their meaning from the context, with which it may be of singular use to compare a word or a sentence whenever they are ambiguous, equivocal, or intricate. Thus, the proem, or preamble, is often called in to help the construction of an Act of Parliament. Of the same nature and use is the comparison of a law with other laws that are made by the same legislator and have some affinity with the subject, or that expressly relate to the same point. Thus, when the law of England declares murder to be felony without benefit of clergy, we must resort to the same law of England to learn what the benefit of clergy is, and when the common law censures the monarchical contracts, it affords great light to the subject to consider what the canon law has adjudged to be simony. 3. As to the subject matter, words are always to be understood as having a regard thereto, for that is always supposed to be in the eye of the legislator, and all his expressions directed to that end. Thus, when the law of our Edward III forbids all ecclesiastical persons to purchase provisions at Rome, it might seem to prohibit the buying of grain and other victual. But when we consider that the statute was made to repress the usurpations of the papal see, and that the nominations to vacant benefices by the Pope were called provisions, we shall see that the restraint is intended to be laid upon such provisions only. 4. As to the effects and consequences, the rule is, where words bear either none, or a very absurd signification, if literally understood, we must a little deviate from the received sense of them. Therefore, the Bolognian law, mentioned by Pufendorf, which enacted that whosoever drew blood in the streets should be punished with the utmost severity, was held long after debate not to extend to the surgeon who opened the vein of a person that fell down in the street with a fit. 5. But lastly, the most universal and effectual way of discovering the true meaning of a law, when the words are dubious, is by considering the reason and spirit of it, or the cause which moved the legislator to enact it. For when this reason ceases, the law itself ought likewise to cease with it. An instance of this is given in a case put by Cicero, or whoever was the author of the rhetorical treatise inscribed to Herennius. There was a law that those who had in a storm forsook the ship should forfeit all property therein, and the ship and landing should belong entirely to those who stayed in it. In a dangerous tempest all the mariners forsook the ship, except only one sick passenger, who by reason of his disease was unable to get out and escape. By chance the ship came safe to port. The sick man kept possession, and claimed the benefit of the law. Now here all the learned agree that the sick man is not within the reason of the law, for the reason of making it was to give encouragement to such as should venture their lives to save the vessel. But this is a merit which he could never pretend to, who neither stayed in the ship upon that account, nor contributed anything to its preservation. From this method of interpreting laws by reason of them arises what we call equity, which is thus defined by Grotius, the correction of that wherein the law, by reason of its universality, is deficient. For since in laws all cases cannot be foreseen or expressed, it is necessary that when the general decrees of the law come to be applied to particular cases, there should be somewhere a power vested of accepting those circumstances which, had they been foreseen, the legislator himself would have accepted. And these are the cases which, as Grotius expresses it, lex non exacte definit, sed arbitrio boni viri permittit. Equity thus depending, essentially, upon the particular circumstances of each individual case, there can be no established rules and fixed precepts of equity laid down, without destroying its very essence, and reducing it to a positive law. And, on the other hand, the liberty of considering all cases in an equitable light must not be indulged too far, lest thereby we destroy all law, and leave the decision of every question entirely in the breast of the judge. And law, without equity, though hard and disagreeable, is much more desirable for the public good than equity without law, which would make every judge a legislator, and introduce most indefinite confusion, as there would then be almost as many different rules of action laid down in our courts as there are differences of capacity and sentiment in the human mind.
But I'm so blessed to be with you today, and it's just an honor for me to be out here, and I really admire this, the folks at this seminary. This is a great school, and I'm glad to be here and present the ultimate proof of creation. I am with the Institute for Creation Research, and what we do is we research those aspects of origins, and we show people that the science confirms what the Bible teaches.
I have now got
just bounce through it really fast. Jay, you're here, right?
Yeah, I'm here, evening all.
Okay. Yeah, I guess we should.
No, I don't want to listen to that. Volume 1 of Corporations. That should be interesting.
Chapter the 18th of Corporations. We have hitherto considered persons in their natural capacities, and have treated of their rights and duties. But as all personal rights die with the person, and as the necessary forms of investing a series of individuals, one after another, with the same identical rights, would be very inconvenient, if not impracticable, it has been found necessary, when it is for the advantage of the public to have any particular rights kept on foot and continued, to constitute artificial persons, who may maintain a perpetual succession and enjoy a kind of legal immortality. These artificial persons are called bodies politic, bodies corporate, corpora corporata, or corporations, of which there is a great variety subsisting, for the advancement of religion, of learning, and of commerce, in order to preserve entire and forever those rights and immunities, which, if they were granted only to those individuals of which the body corporate is composed, would upon their death be utterly lost and extinct. To show the advantages of these incorporations, let us consider the case of a college in either of our universities, founded ad studentum et orandum, for the encouragement of support of religion and learning. If this was a mere voluntary assembly, the individuals which compose it might indeed read, pray, study, and perform scholastic exercises together, so long as they could agree to do so. But they could neither frame nor receive any laws or rules of their conduct, none at least which would have any binding force, for want of a coercive power to create.
Lucidchart makes intelligent diagramming easy and helps your best ideas become real. Start from scratch or get started with templates.
A sufficient obligation. Neither could they be capable of retaining any privileges or immunities, for if such privileges be attacked, which of all this unconnected assembly has the right or ability to defend them? And, when they are dispersed by death or otherwise, how shall they transfer these advantages to another set of students, equally unconnected as themselves? So also, with regard to holding estates or other property, if land be granted for the purposes of religion or learning to 20 individuals not incorporated, there is no legal way of continuing the property to any other persons for the same purposes, but by endless conveyances from one to the other, as often as the hands are changed. But when they are consolidated and united into a corporation, they and their successors are then considered as one person in law. As one person, they have one will, which is collected from the sense of the majority of the individuals. This one will may establish rules and orders for the regulation of the whole, which are a sort of municipal laws of this little republic, or rules and statutes may be prescribed to it at its creation, which are then in the place of natural laws. The privileges and immunities, the estates and possessions of the corporation, when once vested in them, will be forever vested, without any new conveyance to new successions, for all the individual members that have existed from the foundation to the present time, or that shall ever hereafter exist, but are one person in law, a person that never dies, in like manner as the river Thames is still the same river, though the parts which compose it are changing every instant. The honor of originally inventing these political constitutions entirely belongs to the Romans. They were introduced, as Plutarch says, by Numa, who, finding upon his secession the city torn to pieces by the two rival factions of Sabines and Romans, thought it a prudent and politic measure to subdivide these two into many smaller ones, by instituting separate societies of every manual trade and profession. They were afterwards much considered by the civil law, in which they were called universitates, as forming one whole out of many individuals, or collegia, from being gathered together. They were adopted also by the canon law for the maintenance of ecclesiastical discipline, and from our spiritual corporations are derived. But our laws have considerably refined and improved upon the invention, according to the usual genius of the English nation, particularly with regard to sole corporations, consisting of one person only, of which the Roman lawyers had no notion, their maxim being that tres faciant collegium. Though they held that if a corporation originally consisting of 3 persons be reduced to 1, si universitatis ad unum redit, it may still subsist as a corporation, et stet nomen universitatis. Before we proceed to treat of the several incidents of corporations, as regarded by the laws of England, let us first take a view of the several sorts of them, and then we shall be better enabled to apprehend their respective qualities. The first division of corporations is into aggregate and sole. Corporations aggregate consist of many persons united together into one society, and are kept up by a perpetual succession of members, so as to continue forever, of which kind are the mayor and commonalty of a city, the head and fellows of a college, the dean and chapter of a cathedral church. Corporations sole consist of one person only and his successors, in some particular station, who are incorporated by law, in order to give them some legal capacities and advantages, particularly that of perpetuity, which in their natural persons they could not have had. In this sense the king is a sole corporation, so is a bishop, so are some deans and prebendaries, distinct from their several chapters, and so is every parson and vicar. And the necessity, or at least use, of this institution will be very apparent, if we consider the case of a parson of a church. At the original endowment of parish churches, the freehold of the church, the churchyard, the parsonage house, the glebe, and the tithes of the parish were vested in the then parson by the bounty of the donor, as a temporal recompense to him for his spiritual care of the inhabitants, and with the intent that the same emolument should ever afterwards continue as a recompense for the same care. But how was this to be effected? The freehold was vested in the parson, and if we supposed it vested in his natural capacity, on his death it might descend to his heir, and would be liable to his debts and encumbrances, or at best the heir might be compellable, at some trouble and expense, to convey these rights to the succeeding incumbent. The law therefore has wisely ordained that the parson, quatunus parson, shall never die, any more than the king, by making him and his successors a corporation. By which means all the original rights of the parsonage are preserved entire to the successor, for the present incumbent, and his predecessor who lived 7 centuries ago, are in law one and the same person, and what was given to the one was given to the other also. Another division of corporations, either sole or aggregate, is into ecclesiastical and lay. Ecclesiastical corporations are where the members that compose it are entirely spiritual persons, such as bishops, certain deans, and prebendaries, all archdeacons, parsons, and vicars, which are sole corporations, deans and chapters at present, and formerly prior and convent, abbot and monks, and the like, bodies aggregate. These are erected for the furtherance of religion, and the perpetuating the rights of the Church. Lay corporations are of 2 sorts, civil and eleemosynary. The civil are such as are elected for a variety of temporal purposes. The king, for instance, is made a corporation to prevent in general the possibility of an interregnum or vacancy of the throne, and to preserve the possessions of the crown entire. For, immediately upon the demise of one king, his successor is, as we have formerly seen, in full possession of the regal rights and dignity. Other lay corporations are erected for the good government of a town or particular district, as a mayor and commonalty, bailiff and burgesses, or the like, some for the advancement and regulation of manufactures and commerce, as the trading companies of London and other towns, and some for the better carrying on of divers special purposes, as churchwardens for conservation of the goods of the parish, the College of Physicians and Company of Surgeons in London for the improvement of the medical science, the Royal Society for the advancement of natural knowledge, and the Society of Antiquarians for promoting the study of antiquities. And among these I am inclined to think the general corporate bodies of the Universities of Oxford and Cambridge must be ranked, for it is clear they are not spiritual or ecclesiastical corporations, being composed of more laymen than clergy. Neither are they eleemosynary foundations, though stipends are annexed to particular magistrates and professors, any more than other corporations where the acting officers have standing.
This is slightly boring. So anyhow, let me see. Alright. What's her name again? Burgess Speakman. Oops. Huh, hold on a minute. Oh, Burness. There it is. Right. Reclaim your birthright. This is great stuff. Kind of relates to, somebody selling their birthright for a bowl of pottage.
We're going to be talking about some rather serious and interesting information, although hopefully it'll be nothing that'll cause you too much consternation. What sort of sparked this particular line of study is, I don't know how many of you were aware of the gentleman from Indiana who came out and brought codicil and language to our attention, that the word label, as used on the 1040 form, means a testamentary instrument. I was part of the people that brought that lecture forward, and well, I gave Bunny the information, and because we thought it was interesting to look at it in the language at the time the Constitution was written. My personal study was, what is the Constitution in its noun form? Not what does it do, what is the thing? Of course, we've read Lysander Spooner and all the libertarian stuff that's come forward on it being a contract. But after talking to Bunny, I looked up in Amjur and I found, I think it's under Wills, section 12, if memory serves, that the sovereign has no testamentary power at common law. So that means that the Constitution could not be a will, according to the law at the time. And Bunny called me back, about 2 days later, and she said, Stan, guess what? Property can only devolve to a body politic by trust. So what we've pretty much discovered, and I agree with the woman's, with her research, that the Constitution is a trust instrument, and in order for us to understand the peaceful philosophy behind what we're attempting to do in calling government to task, we have to understand that they are trustees. They are very much trustees, and as soon as we understand that, I think that the people in general are going to have a better understanding of where folks like us are coming from. Bunny, if you would, please.
Good morning. My name is Speakman, and I am an heir of liberty. And we're going to find out exactly what that means very shortly. I'm going to prove to you that the Founding Fathers were very lawful men. These gentlemen would not have gone against the law, and they would not have created a document that would have gotten them into trouble. Now, if you logically think about it, what if they had lost the Revolutionary War? They would have been hung for treason, conspiracy, whatever. Okay, so they did create a document that would be legal, lawful, and valid under the king's own law. The colonies had laws when they got here. They brought it with them. They were established at the time of the Revolutionary War and prior to it. And they followed those laws. So when they created the Constitution of the United States, they created it under the common laws that they had brought with them. Now, I'm going to also prove to you that this Constitution that we have here is a trust instrument, and it creates an estate because it all is under estate law. Now, I'm also going to prove to you that the trustees, as far as the heirs, are in breach of trust. And I will show you where you are not an heir, but something else. Now, I'm going to create pictures for you. If you ever put a 2,000-piece puzzle together, there's a little piece here and a little piece there. And we're going to take all these pieces and we're going to bring them in, and I'm going to try to make a picture for you in your mind so that you can actually see it not only in front of you, but inside of you and around you, that you can totally comprehend what we are at effect of today. Now, for example, there's a lack of communication we have with the government. And we have it with each other also. I think of one word and you think of totally something else. You're translating my word in your mind, like the word alienate. Now, how many of you perceive the word alienate or alienation to be a rejection of a sort? Okay. This is going to be the first word we look up in the dictionary. And for those of you who have brought your dictionary, please open it up to alienate.
Which one is that, Rich?
Any dictionary you have. I happen to have the dictionary, the American Dictionary of the English Language by Noah Webster, 1828. I think it's the finest dictionary I have come across, including Black's and Bouvier's. And I use it because in order to know what the Founding Fathers had in mind, what their intent was, you have to understand how they used the words at the time they created something. Okay.
And just for the record, Noah Webster's dictionary is totally based on the Bible. He got all of his definitions, mainly used the Bible as his main reference for any definition.
I will read it. Alienate. To transfer.
The King James Bible, I might add. The real Bible? Yeah.
Title, property, or right to another, as to alienate lands or sovereignty. Transfer title. Okay. Under alienation, still we have a transfer of title or a legal conveyance of property to another. So there goes your communication. We now have set up a communication between each other. Have we not?
More proper.
Okay. Now alienation does not mean rejection. It means to transfer property, to sell, buy, do whatever you want to with it. Okay. Now, keep these things in mind as we go along, okay? Take whatever I tell you and put it up in a little pigeonhole so we can bring it down later. Now, there is in your pamphlets, in your booklets, a diagram like this. By the time we're finished with this class, lecture, whatever you want to call it, this diagram is going to be a living, breathing entity to you. It's going to be reality, I hope. If it's not, then I wouldn't have done my job. Now you will notice on the left side, this is the system according to me. On the left side you see up the top Principles of Liberty and the preamble, the articles, the amendments, down through Amendment 14. And on the right side, you will find up at the top it says Principles of Mortmain. How many recognize the word mortmain? You've read the book.
Not the whole book. I've read some definitions, and I'm a little bit puzzled. So we're going to have to go through this.
Okay, well, mortmain is a very puzzling thing, too, for me because it's been hidden from us. This is the disease that our country is at effect of today. It is the cancer eating our substance. Now, if you can recall back to medieval times, the Roman Catholic Church at one time in England had England in the palm of its hand in a grip that couldn't be let go. This wasn't just a morale or moral issue, okay? It wasn't because all these good people of England were devout Catholics worshiping the church. They had a legal grip on England. They were sucking it dry financially, spiritually, and physically. And it was a legal grip. According to some authorities I have heard or talked with, that the Catholic Church believing it, that the Corpus Christi of Christ being perpetual, so was the Catholic Church. I.e., we have a corporation. Okay? Mortmain refers to corporate functions, corporate principles, the corporate way of doing things, and now we shall look up that word in the dictionary. Again, Black's Law is good for the definition, but again I shall read from Noah Webster.
What are we looking at?
We are looking at mortmain, M-O-R-T-M-A-I-N. Mortmain. French, mort meaning dead and main meaning hand. In law, possession of lands or tenements in dead hands, or hands that cannot alienate. Alienation in mortmain is an alienation of lands or tenements to any corporation, sole or aggregate, ecclesiastical or temporal, particularly to houses of religion, or religious houses, by which the estate becomes perpetually inherent in the corporation and unalienable.
Not transferable.
Mortmain, it means dead hands. Something is in dead hands. It is a death grip on this country. Death grip on this country, the same way it was in England in medieval times. It is the principle our government is working under and upon at this very moment.
Henry VIII saw this.
They all saw this. There were mortmain statutes. And now we're going to commence to go through the literature. Now, all this mortmain, put it up here with alienation, okay? Because it's going to be coming up. Mortmain and mortmain and cypress have destroyed our country. We'll get into cypress. I like to say cyprès because it's a French word and it sounds very elegant. Cyprès. So when I say cyprès, it's C-Y-P-R-E-S-S, 2 words. Cypress is the ability to change a trust. Okay? The authority, the ability, what such are. Now we're going to go to the preamble. I have the preamble sitting here right in front of you. And we'll be looking at that and going to the English laws. Now, the greatest document ever created was the Magna Carta, as far as I'm concerned. Our Constitution today is literally our Magna Carta. Okay? Now, in the Magna Carta, I have given to you, I believe, the whole of it. It's very difficult reading because it's in the Old English words. But if you do read it, and you should, okay, you will notice that it is all, or basically up to a certain point, about.
And just notice how, like, all of this starts occurring after the Lord showed up. All of this Magna Carta and the whole idea that, man is ruled by laws, the laws that come from God, and man has the rights that come from God. All of these ideas didn't happen until after the Lord's ascension. His resurrection and ascension. So anyway.
Inheritance.
Jesus is Lord. That messed up everything.
To inherit your liberty, especially number CAP 1, okay, a confirmation of liberties. Right here, it takes the liberties and says, our liberties are inheritable. We have granted also and given to all the freemen of our realm, for us and our heirs forever, these liberties underwritten. Okay, the Magna Carta makes your liberties an inheritable thing. For as much as we have progressed scientifically, we have regressed spiritually and legally. Okay, we are definitely in feudal times.
Because, of course, all law is spiritual. So this lady doesn't, I'm not getting the impression she knows her Bible. So, but anyhow, that's this is exactly what the Bible tells us straight up. So again, we're failing in our duties. That's why this nation is crumbling and fallen back under the Roman system. Back under mortmain.
Now back to the Magna Carta. The first one is about the liberties. The second one is the relief on the king's tenant of full age. Third is wardship, and these are all inheritances, okay? Fourth is about wasting. Now, wasting is very important, okay, because this will come up later. I presume I can see that the 14th Amendment is projected toward people who waste, okay? In CAP 35, it discusses liberties purchased. Okay, if you weren't a free man or if you didn't have a free estate, you literally purchased your estate and your liberties were derived from that idea of purchase. Okay, these are things just skimming the top so far. Now, at 36, we come into mortmain. It shall not be lawful from henceforth to give his lands to any religious house. Now, the reason they had religious house, why they specifically were pointed at religious houses, because the Catholic Church was a corporation. Catholic Church, and I don't mean to knock or poo-poo the Catholic Church or any other religion, it just happens to be the way it was at the time. So,
I mean to poo-poo the Catholic religion. I have no problem poo-pooing the Catholic religion. Your Roman popery, your Babylonian bullshit. Away with you devils.
Catholic Church was a corporation, and they were attempting to prevent it from sucking the wealth out of England. A person would die or was about to die, and he would bequeath his estate over to the Catholic Church for the saving of his immortal soul, leaving the heirs destitute or out on the street.
And you wonder how the Catholic Church became the most powerful organization / corporation on earth? And you there's no way to prove it now because of all they have thousands of different corporations and entities and trusts and LLCs to hide behind.
So this was an attempt on their part to prevent that to the Catholic Church as a corporation, because it was in dead hands and they couldn't get it back. It kept revolving in dead hands. Okay? Quia emptors, I put this in there. You should probably read it at your leisure. It applies also. The next page is the Statute of Mortmain, 15 Richard II, 1391, Chapter 5. Again, they're trying to stop the eating of the corporate power in the country. Or am I saying that right? Do we get it? Okay. Now we're going to get in. If you have a question, please write it down so that at the end, after the taping, we can get back to the question, because I hopefully will answer anything that comes up and you can just scratch your question off.
Well, this pertains to the legacy line, too. So do these references here match what's in legacy line?
Most of them, yes. This is where I got legacy 1 and legacy 2. Okay. The statute of wills. Now, when the question came up, just what is the Constitution, I had an inkling. I mean, someone gave me the input that, it had something to do with a will. There was will structure in it. So I started to, reading about wills. And it led me to the statute of wills. And in the statute of wills, you will notice by the star where it says, hereditaments holding of the king, his heirs or successors, or any other person or persons by knight service, shall have full and free liberty, power, and authority to give, dispose, will, or devise to any persons except bodies, politic, and corporate. Okay? So the Constitution as a thing right there told me it could not be a will. Couldn't possibly be a will. It was against the common law. It was against the laws of England, of which the founding fathers were following. Okay? I then came to the statute of uses, and things began to start looking familiar. In the statute of uses, down at the bottom, where it starts to read that where any person or persons stand to be seized, or at any manors, lands, tenements, rents, services, reversions, remainders, or others, or any body politic by reason of any bargain, sale, fee offment, fine, recovery, covenant, contract, agreement, will, or otherwise, by any manner, means whatsoever, it shall be, in every such case, all and every such person and persons and body politic that have or hereafter shall have any such use, confident, or trust in fee simple, fee tail, or term of life, 4 years, etc., shall from henceforth stand be seized and deemed and judged in lawful season. This is saying that this creates a trust, a use, actually. I put something in trust for your use. I am the trustee. I'm not only the trustee, but I'm the testator or the trustor. I'm a person who creates it. But I put something into trust so that you can use it. It's actually yours and mine, but you can use it. It's a use. They called it the statute of uses. Trusts and uses are basically the same thing. They fall under the same idea, the same conditions. Okay, that started to ring a bell. To use. Yes, I should be able to use it. And then I came across the statute of charitable uses, and things really begin to look familiar. Now, in the statute of charitable uses, you shall find that which looks very familiar, like the Social Security system, the repair of bridges, ports, havens, causeways, and highways. You will find supportation, aid, and help of young tradesmen, handicraftsmen, persons. You will find the word other taxes in it. Okay, this is a very important statute. The statute of uses and the statute of charitable uses are the big ones. Then on the next page I have the statute of fraudulent deeds, alienations, etc., which is a statute 13 Elizabeth 1, 1570, chapter 5. Now, Elizabeth, this was after the overthrow of the Catholic Church. They were now Protestants and had gained control back of England. What happened was, I guess people just got fed up with the whole situation. They got tired of the corporate Mortmain structure keeping them in dead hands with the death grip, got rid of the king, got rid of the church, and now we have Elizabeth.
I mean, how does anybody not see, you know what I mean, what the Catholic Church is? I mean, is there any more prophecy, more clear in the whole Bible than the Catholic Church being the whore of Babylon? And if you look all throughout history, she shows you what a whorish bitch she is. All right? That, does that sound like the bride of the Lamb that would, the old lady that gave her last 2 pence is an example of God's church versus this other greedy-ass church that's going to hold everybody in a death grip? That doesn't sound like the Church of God at all. That sounds exactly the opposite to me.
Who is Protestant, and she creates the statute of fraudulent deeds. And in here, you will find that if there's any fraudulent situations over conveyances, like trusts, deeds, you are now in jeopardy. By guileful and covetous or fraudulent devices and practices, as aforesaid, we shall or might be in any ways disturbed, hindered, delayed, or defrauded to be clearly and utterly frustrate and of none effect. If you created trust that was fraudulent, it was of none effect. So therefore, if the Founding Fathers were creating a trust in the Constitution, it had to be lawful. It had to be lawful. We go again to...
America was great because of our laws. That's why this nation prospered unlike any other upon its founding. Up until the Civil War, America was booming, baby.
The statute against collusive and fraudulent conveyances, which also upholds this thought and line of idea. Number 3 down in the first paragraph says, or else by any secret intent of the parties, the same to be their own proper use, and at their free disposition. Number 4, colored nevertheless by a feigned countenance and show of words and sentences as though the same were made bona fide for good causes. Still upholding the fact that if you are creating something, it has to be lawful. It has to be lawful. This is the common law. This is the law of England. And this is the law that the Founding Fathers went by. They were lawful men. You will find constantly through these statutes repeatedly inheritances.
All of them were absolutely influenced by William Blackstone.
Repeatedly inheritance, repeatedly body politics, corporate, so that you can literally separate who is who without everything being piled up into a mishmash. We have the statute of frauds. It's a very important thing. We can't get to the statute of frauds when we go into court these days because the laws and the workings of the Mortmain government is not in its reach. It's not in its reach. We're going to show you how and why it's not in its reach. Okay? So when you go into a court saying, you know, this is fraudulent, the judge sitting there going, no, I don't think so. No, because you can't get to the common law. You are barred. The little diagram I showed you, there is a bar going down between.
You are barred. Huh. By maybe the Bar Association? Fucking evil motherfuckers.
Between the two columns on the right and the left, there is a bar that goes down between the principles of liberties and the principles of Mortmain. We're literally stuck into Mortmain in dead hands. That's why we feel so frustrated when we go into court, knowing that there is justice somewhere, but we're not experiencing it, we're not feeling it, we don't see it, we don't get it, something's wrong. We are barred. We keep coming up against the steel wall. Now, in order for you to understand where the power lies, the power does not lie in the articles, nor does it lie in the amendments. The power lies in the preamble. It is the preamble that creates the estate. It is the preamble that creates the trust. It is the preamble who tells you who it is, or who it isn't, actually. Okay? You must understand what an estate is so that you can see it. So that you can see the estate lying in here, and so that you can see the trust. Okay, we know that the English laws, it had to be a will or a trust. It wasn't a will. We're going to presume it's a trust because they had to make it legal and lawful. They weren't going to get hung. I don't think so. If I were to create a document today, I try to make things, my documents lawful. I'm trying to follow their laws, doing it right all along. Okay, so they were no different than we are. And I am a lawful person. You're going to have to turn this one sideways. This that we're going to go into is a book written by an Associate Justice of the Supreme Court, Henry Baldwin, in 1837 it was published. And it's a rather large, it's much larger than what I have given you. It's literally a book, and bless my friend who gave it to me, because she said, well, so-and-so says this, that, and the other, and it's found in here. And I said, oh, well, I'd like to read this. And when I read it, I said, well, so-and-so missed something. He missed on page 3 the first parts of these things. Okay, down on the bottom, you see where it starts out, to me, just above the star. I'm going to read down. To me it seems that it can be made intelligible, we're discussing the Constitution, in all its parts by applying to it those established rules and maxims of common law in the construction of statutes, and those accepted definitions of words, terms, and language in which they had been used and had been received as well known and understood in their ordinary or legal sense. That's why I have the Webster's Dictionary of 1828, because that's what the Constitution was written on. According to the subject matter, in appealing to the common law as the standard of exposition in all doubts as to the meaning of written instrument, there is safety, certainty, and authority. The institution of the colonies were based upon it. It was their free system of jurisprudence, with only local exceptions to suit the conditions of the colonists, who claimed it as their birthright and their inheritance. The common law was their birthright and their inheritance. So they were claiming the liberties that were given to them under the great charters and the laws of England. The Magna Carta bequeathed, brought up the inheritance of liberties. And here they are claiming their inheritance, their birthright. We're having a problem getting to our birthright today.
Ooh, we sure are.
This
was done in like the 90s, I think. So, I mean, yeah, 2026, boy, we got big time problems, homie. This shit's almost completely Catholic. We're so close.
Page. From the beginning, I guess that's the first paragraph down, the little star up at the top. From the beginning till the consummation of the Revolution, the people of the colonies and states in all successive congresses, they had congresses at the time, took their stand upon the common law and Constitution of England as the heirs of freedom. English freemen, whose custom it is derived from their ancestors to make those tremble who dare to think of making them miserable. God bless them. Heirs of freedom. They didn't claim to be sovereign state citizens. Sovereign state citizenship did not exist. It didn't exist until the king said, "Here is the Treaty of Peace. You're a sovereign citizen," or whatever he said. It didn't exist. Who were they? What were they to call themselves? They called themselves heirs of freedom. This preempts state citizenship. This is who they define themselves as. You won't find a state citizen mentioned in the preamble because it did not exist. But an inheritance did. So did estate laws. So did trusts. So now we have heirs of freedom.
Just for the record, trust law is the oldest of all law. Man law, anyway. Not natural law, but like written law. So anyway.
Freedom. An heir. Down on the bottom again, it mentions more about the inheritance left us by our forefathers. Our inheritance. The great bulwark of our Constitution, the first and best maxims of the Constitution. You think
I want to check something out right quick. Where is my blue letter Bible? There it is. Bulwark. Oh, what was it? Oh, okay. Misspelled it. What am I, retarded? Oh, okay, A. It's an A. B-U-L-W-A-R-K. Okay. Okay. In that day shall this song be sung in the land of Judah. We have a strong city. Salvation will God appoint for walls and bulwarks. There was a little city and a few men within it. And there came a great king against it and besieged it, and built great bulwarks against it. Alright, sorry.
The best maxim is the Articles or the First Amendment? No, it's in the preamble. It's the first maxim. Venerable to Britons and Americans, whose forefathers participated in the rights and liberties they boasted of and conveyed the same fair inheritance to them. We have a conveyance. Convey, inheritance, freedom. It was called the covenant chain on the next page at the star, between the mother country and them. The charters of the king were their written civil constitutions of government, and the colonies would not part with or lose their hold of this covenant chain. There is a covenant of liberty. Covenant, promise, guarantee, secure, insurance. It's a covenant. Now, you should read this. It's very important. It's boring to read all of this. I've gone through book after document, sucking it all in, absorbing it, getting the picture. And I keep coming up with, and you should too, look for your inheritance. In today's laws, you'll find in, say, Amjor 2D, you'll read a sentence and you go, I don't get this, I don't understand it. Well, that's not talking about you. Guaranteed. When you understand the trust and the estate, then you can go and read something in Amjor and you will find yourself segregating everything because it has been commingled. Everything has been commingled, which is a no-no in trusts. Okay? Now, back to this. On the next page, which would be 6, okay? And please don't laugh. There is a circular object. This is the seal of the Magna Carta, okay? I said not laugh. Okay, that was you, wasn't it? I know. Okay, now you will notice in here. Let's see, where do I find to the journal? Okay, to the journal published by their order. Now we're talking about the Founding Fathers and their first Journal of Congress. Okay, to the journal published by their order and verified by the autograph of their secretary is prefixed in the title page, a medallion of which the following is a facsimile. The medallion is the Magna Carta, the seal of Magna Carta on the first Journal of Congress. The Magna Carta of England was the pedestal on which the column and cap of liberty was raised, supported by the 12 colonies assembled by their delegates, declaring, "On this we rely, on this we shall defend." They are defending their inherent liberties as enumerated in the Magna Carta. They had written this. This was already written, but they were defending the Magna Carta because the Magna Carta is in here. You don't see it, but it's in there. They were defending it. They brought it down forward, and they were passing it on in the preamble. They created an estate of liberty, and it's sitting there in the preamble. Your liberty is an estate. There is page 10, second underlined section. I underline everything. It's for my posterity to find. Page 10, it says, now we're still discussing the Constitution by Mr. Baldwin. And he says that the Constitution, the intent by the framer was to endure for ages to come and designed to approach immortality. Now, it truly is. This is the finest document in the world. It is beautiful once you get to see the picture of it all. What the Founding Fathers left us was the finest estate in trust that this world has ever known. And through guile...
Ooh, I mean, that's, she's nailing on something tight, but let me just bring this to your attention here. Hold on, let me go to...
That's why there is no diabetes in Israel. If you are a Christian and don't know that type 2 reversal is in the Bible, read the scriptures again. This drink, mentioned more than 30 times in the scriptures and known as insulin...
All right, so go ahead. Now, what is this? We're looking at...
So what we've got here is a copy of the painting by Sir Peter Lely. It may be one of the, the original, it may be one of the original copies, certainly made by Lely's studio at the time when the original was painted. So in the 1650s, Sir Peter Lely painted Cromwell. Reputedly, when Cromwell arrived at his studio, Lely said, how do you want to be painted? Is there anything you want me to miss off? And Cromwell says to him to the effect of, Mr. Lely, if you don't use your talents as best you can, if you don't paint me as I am, pimples and warts and all, I shall not pay you a farthing. Supposedly, therefore, this is an accurate representation of Cromwell. This may be the original. There's one in Birmingham Museum, which may be the original. There's one in the Pitti Palace in Florence, which also may be the one. But either way, it dates from this particular period and from the studio of Sir Peter Lely. So, of course, we remember this today when we still talk about something being warts and all. I suppose that, to many people, is the sort of image of Cromwell. It's somebody who is very plain-spoken and didn't want to be represented in any other way than he actually was. I suppose that's the sort of the bit that most people find admirable about him.
For centuries, Oliver Cromwell has been a source founder of Rhode Island. And in between Williams and Oliver Cromwell is a panel dedicated to the Pilgrims who landed at Plymouth and who signed the Mayflower Compact.
They were originally headed to set a new plantation, a new settlement in northern Virginia, but they got off course. They landed too far north, and realizing they were out of the technical jurisdiction of the Crown and the King in Virginia, they decided they would establish for their own body politic, their own type of civil government, and that's what the Mayflower Compact is. The relevance of that is that it would allow the people, it recognized the people had the right to govern themselves, to establish their own forms of government, adopt their own laws, and do so consistent with the laws of God.
The first founding fathers that you had coming to your country, from the Pilgrims of New England, they were all Protestants seeking religious freedom from the state churches in Britain and other parts of Europe. So you could see right from the very beginning in the Mayflower Compact and many of the documents that we have from the earliest founding fathers of the United States, that there's no doubt that the Reformation teachings greatly influenced them, and seeing the states as being the servants of God.
The reason the Mayflower Compact is important is because these people, our founding fathers, they swore an oath to God. And God is going to hold us accountable to it. We are being held accountable to this. We are part of this in our time. That's why this is super important. That, yeah, you better stand up and gird up your loins. Americans, gird them up.
A minister of justice.
Yet years before the Pilgrims landed at Plymouth, the Jamestown settlement began in the year 1607. The early settlers set up a cross to commemorate the establishment of their new colony. A minister named Robert Hunt prayed the following prayer: "We do hereby dedicate this land and ourselves to reach the people within these shores with the gospel of Jesus Christ, and to raise up godly generations after us, and with these generations take the kingdom of God to all the earth. May this covenant of dedication remain to all generations, as long as the earth remains."
See that? We're bound.
And may this land to all generations.
Pay attention, America. That's why it's a shame that we all can't use the same Bible, the real Bible, and quit having all of these different denominations and be one body, one mind, one gospel, one Jesus.
As long as the earth remains, and may this land, along with England, be evangelists to the world. May all who see this cross remember what we have done here, and may those who come here to inhabit join us in this covenant and in this most noble work, that the Holy Scriptures may be fulfilled. The Scripture.
Big amen on that. So now,
practices. We, the heirs of freedom, have literally had our estate stolen from us, our inheritance, our liberty. It is an estate. Now, over on the right, you will see that the Constitution is a grant. Trusts, grants and trusts go in the same hand. They're hand in hand. A grant creates trust. It creates a use. Okay? Let's see if there's the grant does not convey power which might be beneficial to the grantor if retained by himself, or which can move solely to the benefit of the grantee. Okay? The government says, well, this is a grant. They granted us power. Yes, we did. The people, the founding fathers granted them power. But the power that was granted was for them to work in a corporate structure and applied only to things that they owned or that which was ceded to them or granted to them. So under their corporate structure, they had to own it, have it ceded to them, or have it granted to them. And that's how the corporation worked. It worked on those things. Only those things. Down at the bottom, you'll see I have the words things written on there. This gentleman is beautiful. I mean, he so defines it. Constitution creates things, not names. We're going to be constantly looking for the thing that it creates. Okay? In the preamble, the thing is the estate. There are no names there. It's a thing. Okay, page 24. Now, in this paragraph that I have marked, Mr. Baldwin starts to discuss, no, it's the second paragraph down, states, inherent rights, okay? This is the essence of supreme and sovereign power, which testifies that the ultimate absolute sovereignty is in the several states and the people thereof, who can do by inherent right and power anything in relation to the Constitution or change of government, except depriving a smallest state of equal suffrage in the Senate. Not in the United States or the people thereof as one nation or one people, who in their unity of character or power can do nothing either by inherent right or representation as a majority. Inherent rights.
Let's hear that again.
Of the people of the states, not the people majority. Nation change of supreme and sovereign power, which testifies that the ultimate absolute sovereignty is in the several states and the people thereof, who can do by inherent right and power anything in relation to the Constitution or change of government, except depriving a smallest state of equal suffrage in the Senate. Not in the United States or the people thereof as one nation or one people, who in their unity of character or power can do nothing either by inherent right or representation as a majority. Inherent rights of the people of the states, not the people of the United States, but the people of the states. Who are the people of the United States? They are 14th Amendment citizens. 14th Amendment citizens have no inherent rights.
Ta-da! I certify that I am a U.S. citizen. Check here, please.
Only the people of the state.
Get out and vote. You better get out and vote. Do your duty and vote. And then on that voter registration card it says, I certify that I am a U.S. citizen.
The several states.
Uh-oh. Adhesion terms, because I hereby certify under penalty of perjury that I am a U.S. citizen.
Baldwin. Lovely. The features of the British and federal governments compared. Okay. Down by the little arrows. The powers not delegated or prohibited being reserved to the states respectively or the people, none can exist by prerogative or inherent power in any branch of the government. Hence, the effect of a specification of the powers granted and prohibited and the express reservation of all others leaves to the states all the prerogative powers of the king over those subjects which are involved in these four cases, the ones that Mr. Baldwin was talking about, or going to be looking at, either directly or collaterally, on none of which any powers granted to the United States by this Constitution. Then he goes into charters of incorporation, franchises over public rivers, etc., etc. Now then he goes into descent, okay, and he says that the King of England we're discussing is a natural person on whom the crown descends by hereditary right as real estate does. This here is to come to us by descent and distribution. Okay, it descends upon the heir. You don't choose it. It just comes to you. It's yours. It descends like I drop it on you. It falls upon you. Devolves. We got to try to keep this simple. On page 56, Mr. Baldwin says, in other respects, the great features of both governments are the same. Both established by the people of the estates, E-S-T-A-T-E-S, of one, the states of the other. Each state or estate represented by their representatives in distinct bodies. Okay. Estates and state. Could the state of California be the estate of California?
Sure.
Yeah.
Absolutely. Now we are going to stop and we're going to look for a definition of estate. Estate, in Noah Webster's Dictionary of 1829, number 1, in a general sense, fixedness, a fixed condition, now generally written and pronounced S-T-A-T-E. And number 6, the general business or interest of government, hence a political body, a commonwealth, a republic. But in this sense, we now use S-T-A-T-E. So here we have 13 colonies who are going to be, who are 13 estates, creating a document of estates for the people of the estates. And when I say the word state from now on, it is going to mean to you estate. even if it's a capital S as compared to a small s, because there are separate estates. In reality, I perceive the capital S state to be a corporate function in Mortmain. Perceived, oh, now we can go back, okay. Okay, page 58, we go into the estates again. And Mr. Baldwin he goes into the estates of England, who they were, what their function was. And down at the marked section, the lords represented the two estates of the nobility and clergy. Okay, page 58. They sat in their own right, representing themselves and property as two estates or states of the nation or realm, wholly distinct from the third estate or state. That estate was the whole body of the people, represented in the convention of the commons. As there was no king, there could be no parliament or house of commons in any other capacity than in convention. Pardon me. This was at the time when the throne was abdicated. Life went on as normal. In England, the representatives still met. They still passed laws. They did everything they were supposed to do until the crown was placed upon another body, human entity. So at this point in our time, you can guarantee that our crown has been abdicated, or they are trying to abdicate the throne by getting rid of the sovereign state citizens as we know them and making everybody into a United States citizen who has no inherent power. The state citizen has it, not the United States citizen. So how do you gain the power? You get rid of the state citizen. This is genocide. This is absolute genocide. Now you can all say they're genociding me, and you know that they are. They have. Whoever they are. We're going to come to find out that you yourself is genociding yourself, or have genocided yourself. But you were forced to. To have this estate has either become illegal or it is null and void, according to law. Not moral law, but according to written law. Now, okay, do we all get what an estate is as far as, I mean, superficially that we're discussing estates? Okay, and we all agree that we have an estate. Now we're going to find out what an estate is and what it looks like.
What page are you on, Dan?
We're going to go to an introduction to the law of real property. This is an excellent little book. This is the little book. It's a little book. It's lovely. It's beautiful. Cornelius J. Moynihan. Now, what does an estate look like? What is an estate? Page 28, Chapter 2, Freehold Estates. Sounds good to me. Freehold, holding it freely. It's free. And you will go to the underline and mark spots. Okay, and okay. The word estate is a feudal origin and is derived from the Latin word status. Please send us your Social Security number so we may know your status. What your estate is. It speaks to us of time when land holding was inseparably connected with a man's political and personal status in the community. I say that it is still connected.
Very much so.
The next paragraph. The estate in fee simple is of potentially infinite duration. A life estate, or estate for years, is a finite duration. Life estate, freehold, fee simple. Okay? These are two different types of estates. We have the fee simple absolute is one type, life estate is another. On the other page, an estate in fee simple was and still is the largest estate known to law. It donates the maximum of legal ownership, the greatest possible aggregate of rights, powers, privileges, and immunities which a person may have in land. Now, when it comes to your rights, okay, when it says may have in land, all of your rights as a human being attached to the land or the estate you are in possession of. Okay? You might not own any land, but there is an estate and your rights attach to that particular estate. This estate here was a fee simple absolute. Is a fee simple absolute. Okay. Littleton, in his famous treatise of tenures written in the 15th century, began his book by defining the estate thus: tenant in fee simple is he which hath lands or tenements to hold to him and his heirs forever. This definition is still valid. Now, do you notice right there where it says to hold to him and his heirs forever? This is very important. Just those words. Okay? To him and his heirs forever. On the next page, you will see the statute of uses brought into our line of thought and estate. And down at the bottom, you'll see that the law of real property of today is result of the application of both common law and equitable doctrines, and it was by means of this institution of uses that equity came into contact with the land law. Now we have, it's melding, okay, it's coming together. The statute of uses creating a trust now connects to the land, okay? It comes together. The beneficial enjoyment, like I said, the trust was for your use. A trust is for your use, your beneficial enjoyment. Your enjoyment, period. On page 219, let's skip that page. We'll go to the survey of law of property. Okay? Because this is where we're going to see the trust or the estate in the preamble. And I wish this was a little clearer copy for you. I must apologize. Down in the paragraph that I start underlining, now in law, when you have an object to convey, they don't use the person's name, okay? A, B, C, D, X, Y, Z represent a person, a human being. Black acre or white acre or green acre, some sort of acre, represents the object they are conveying. Okay, so if I say A conveys black acre to B, I'm A, you're B, this is black acre. Okay, now we know that we're talking about people, who I am, who you are, and what I convey. A conveys. So in the paragraph below, okay, we're conveying a fee simple absolute in this paragraph. It was an estate in fee simple, which is the largest estate known to law. It donates the maximum of legal ownership, the greatest possible aggregate of rights, privileges, and powers and immunities. Again, we have said we go to rights. Okay, we're conveying rights. Everything is in the estate. Privileges, powers, and immunities which a person may have in land. Again, it attaches to the land. It is not separate from. It is of potentially infinite duration. By the year 1250, the words "and his heirs" had become the only ones by which a fee simple could be conveyed. The word "be" and his heirs meant be in fee simple without any qualification whatsoever. But the words "be" in fee simple used in a deed would give "be" only a life estate. Okay? The words in the deed had to be "be and his heirs." The words "and his heirs" used in a deed were construed as words of limitation. Limitation? Say what? Wrong. That is, they describe the quantum or size of the estate transferred to be. The size. It wasn't a restriction, a limitation. It was not the restriction. It was the size of the estate. Strange as it may seem, the word limitation is contrary to what you think it should be. It's the size. The words of limitation indicate what is taken. Words of purchase indicate the grantees or persons who take it. We must be very clear. Okay, when you name somebody, now we are saying something about words of purchase. Okay, if I were to say A conveys Blackacre to B and his heirs and his son John, we just limited the size of the estate. We made it smaller. When you name the heir, it lessens it. That is why the heir is not mentioned in the preamble. We the people, A, convey Blackacre for a more perfect union, establish justice to ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty. This is Blackacre. This is the estate. It is the estate. A conveys Blackacre to B and his heirs. Right there is the estate. Do you see it? Do you get it? Mm-hmm. A conveys Blackacre to B.
Do you see it? Do you get it? You like it? So yes, this is where, this is why I've been led to believe that the place prepared in the wilderness for the bride of the Lamb during the second half of the tribulation, the only place that makes sense is America. The Wild Wild West. A place prepared in the wilderness by a bunch of wild olive branches. I love it.
Be in his ears. It's sitting right there. Have you ever seen it? Did you ever see it before? No, you've never seen it before. It's beautiful, isn't it? It's an estate. It's an estate being conveyed. It is a fee simple absolute, a freehold.
But see, if they can get you to volunteer to be a, U.S. citizen besides a citizen of whatever state that you reside in, that's why they play little word games. There's a big difference between the word domicile, where you domicile, versus your residence. So, this is, it's coercion, dude. This is why they took logic out of schools, why they take law out of schools. They don't teach us law in public schools. You got to pay big money for that, to learn the technology of law and knowing your rights and everything. So, that's why the education system is just such a fucking mess. It's garbage. People are being taught what to think, not how to think. That is the problem.
Who are the heirs? You can't name them. That's why they didn't put, we the people conveyed to ourselves and state citizens. You say, if they said that, it would have diminished not only our estate, but their estate. They were getting a life estate if they did that. They protected themselves, their estate. They protected our estate. It's of indefinite duration. It can last forever. Infinitely and infinitively.
And all of our founding fathers that wrote these legal documents were all influenced by Blackstone. William Blackstone. A brilliant legal mind that influenced all of these. These were his young men that came over and founded this country.
Infinitely, right. It's a fee simple absolute. I saw this and I thought, my God, that's beautiful. It's absolutely beautiful. It's right there in front of all of us. And we've never seen it. Never saw it. But why haven't we seen it? Could it be being kept from us?
Could it be? Why, who would want to steal your inheritance? Could it be? Who would want you to subject yourself to slavery versus being free, accountable to God, God alone? I like that better. Much more better. See, and this is a matter of, why our citizenship in New Jerusalem, why, we have dual citizenship as believers. So this is why, when you are subject to the Lord Jesus Christ, then you are not subject to this, this ungodly system of law.
I never learned this in school. So there we have the fee simple absolute. Like I said, if they had named the heir, if they had done anything to signify who the heir was, it would have lessened the estate and it would have become a life estate. Now, when you come to a life estate, you have problems because there are things that apply to it. You have responsibilities. To continue on with the fee simple, you'll notice on page 8, I have a few things underlined, such as if, now we're discussing the heirs or the parties of the estate, and if he dies intestate without any heirs, lineal or collateral, the property escheated to the overlord in feudal days, and now would escheat to the state. The estate, B's estate, will last only as long as he has heirs. Therefore, we have the 14th Amendment getting rid of the heirs. The estate lasts only as long as there are heirs. That is why we hear from these offside routes that the preamble or the Constitution is outdated and outmoded. Yes, because they have gotten rid of the heirs and it is not valid anymore. Why should we keep it around? Let's get rid of it. I heard by word of mouth, I don't keep up with these things, that one of the people who ran for presidency last time wanted to have a constitutional convention. Well, if the throne has been abdicated, a constitutional convention is proper so that the throne can descend to something or someone else. Because we no longer need the Constitution as it is. It's outdated, isn't it? Mm. Well, you might think so, but I don't. On page 34, we come to a thing. You will notice that I have put some writing up at the top. It says restraint on alienation. Okay, case 40. A being, the fee simple owner of Blackacre, executed his deed to B as grantee in the following words. I hereby grant Blackacre to B and his heirs, but upon the express condition that it shall not be competent for B to dispose of or alienate said Blackacre for a period of 5 years after he receives the title of such property. Okay, so someone's attempting to pass a fee simple absolute here with a big but. But he can't do this or that or the other. So what type of estate does he really have? And down there you'll see the answer is C has a fee simple absolute in Blackacre. This question does not involve either a determinal fee simple or a fee simple on conditions subsequent, for no intention appears on the face of the deed. Here is a fee simple estate vested in B. The grantor then attempts to impose upon the grantee, B, a restraint
When you sign up for Social Security, you alienate your freehold estate to the United States government.
attempts to impose upon the grantee, B, a restraint on his power to alienate or dispose of.
Another term may be called expediation. I can't read that.
The feast.
However, you are never
simple estate
fully informed of your actions in, man, I cannot even read that. In
is such restraint valid?
Regards to your birthright freedoms. In its place, you are given that which is called
the answer
equality and civil rights. There is nothing equal about them being in a state for life. It can be diminished beyond recognition or
you
completely
have no
removed.
power, no right to restrain a fee simple.
So let's
question
hear them
is,
explain
C
that
has a
instead of
fee
me
simple
trying to read it.
absolute in Blackacre. This question does not involve either a determinal fee simple or a fee simple on conditions subsequent, for no intention appears on the face of the deed. Here is a fee simple estate vested in B. The grantor then attempts to impose upon the grantee, B, a restraint on his power to alienate or dispose of the fee simple estate. Is such restraint valid? The answer is an unequivocal no. You have no power, no right to restrain a fee simple absolute in any way, shape, or form. You can put no conditions on it. Restraint on alienation. Pigeonhole that word. Because at this time, your Social Security number is a restraint on alienation to that estate. Okay, let's see. I am now on page 79. We're going into freehold estates still. An estate of freehold is an estate of indeterminate duration other than an estate at will or by sufferance. Again, it says so, indeterminate duration. This is what makes the Constitution infinite, to last for all ages, for all societies. Okay, this makes it immortal. It's beautiful. It is an immortal thing. It's there. Life estates, life estates. Life estates, now, I should have something on life estates in here. I know they're there. I hope we get to them. But we're going to throw something in on life estates. When you get to life estates, we have conditions on estates, okay? You can no longer waste. In a freehold estate, the fee simple absolute, the heir or the posterity, the person who has the estate, they can waste any portion of it they want. They can burn it, shred it, throw it away, give it away, anything they want. That's waste, okay? That owner can waste. But when it comes to a life estate, no, 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 no. There is no wasting in life estates. No wasting in life estates. You're subject to duties, regulations, and laws. Wonder what kind of estate the 14th Amendment is. Here's a good one.
What page are you on, buddy?
We're still on, we're on page 80. Some of the authorities, this is the third paragraph down, in an attempt to exactitude,
That an exactitude? I'm not always good at reading. Okay. Have employed the term fee simple absolute in such a case or in such a way as to set it off as a distinct legal concept. Totally new concept. Thus it has been stated that an estate in fee simple absolute means a perfect title. It is the entire and absolute interest and property in the land. Interest in the land. Your rights and duties to it are an interest in that. You have no duties, though, in a fee simple absolute, so your privileges, immunities, or everything is an interest in the estate. Difficult to pay. Page 81. Second sentence, there can be only one estate in fee simple to a particular tract of land. It is an estate of inheritance unlimited in duration, descendable to all the heirs of the owner alike to the remotest generations. And aside from the fact that it may be created so as to be defeasible and subject to executory limitations, or granted or devised subject to a condition subsequent, it is, with respect to its duration and enjoyment, as an interest in property, clear of any qualification or condition. It has been defined as an estate of perpetuity, confining an unlimited power of alienation, that or than which no person is capable of having a greater interest. And down at the bottom in the footnote, you will see that an estate which must be a fee simple is absolute, complete, and self-sufficient. An estate which must be nourished or kept alive by the grantee is obviously conditional or qualified or limited. This element of insecurity implicit in the grant impairs the totality and permanency of the estate, and such an estate is not a fee simple. Insecurity? Are you feeling insecurity with your estate? If we had our estate, we would not be feeling insecure. And insecurity is running rampant in this country amongst people. Heavy insecurity.
Are you feeling insecure with, $34 trillion in debt? How's that make you feel?
Securities.
Ridiculous.
Not trusting the other person, not trusting your brother, your sister, blaming everything on someone else. He did it. Republicans did it. No, the Democrats did it. No, the Latins did it. The Spanish did it. The Mexicans did it. The black people did it. The white people did it. The Koreans did it. Somebody else did it. Nobody is taking responsibility. They don't know who did it. They have absolutely no idea what's going on. Oh, let's see. Use possession. On page 83 in estates, it brings up the use and possession of property constitutes a gift. Let's see. Oh, we have the metaphysical concept of title. I like that word metaphysical. For a long time I thought metaphysical meant I didn't understand until my good friend said metaphysical means thinking, thought process. Okay. I like that word. I can understand thinking. It seems like that's all I ever do.
Well, if you quit, you're in trouble.
Yes, I believe so. I'm passing on to more pages. Okay, exception to the rule, reservation of the grantor. Here, we must understand exceptions. Okay, on page 90, The common law rule requiring words of inheritance in a conveyance to pass a fee simple was subject to many well-established exceptions. Thus, although it was usually held that words of inheritance were necessary to establish a fee in a grant containing a reservation in favor of the grantor, because a reservation is technically speaking a regrant of the property, no words of inheritance were necessary to establish an exception in fee simple in favor of the grantor, since an exception excluded from a conveyance that which would otherwise pass. Now, in the Constitution, the Fifth Amendment and certain things are exceptions. That power that was reserved to the people is an exception. Okay, now exceptions are very important when it comes to the estate. Okay, even though they put words of inheritance in here, okay, there are still found exceptions in the body of the Constitution outside of here. And we must find those exceptions at times. In the Fifth Amendment, were reserved. This is, by the way, this is where liberty is in the Fifth Amendment. I had a couple pages of index on the Constitution, what is found where. Liberty is only found in the Fifth Amendment. That was interesting. The let's see, the blessings, where is it? There, nowhere in the Constitution is found domestic tranquility. There is no corporate power to administrate domestic tranquility. Yet it's in the preamble. It's part of the estate. It's supposed to exist. Obviously, we're not getting our domestic tranquility these days, but yet it is part of the estate and is not listed anywhere or even under any subject of the remainder of the Constitution. And liberty is only found in the Fifth Amendment. Now, the common defense and everything, all these other words, common defense, general welfare, that is enormous, and that is what they're administrating under the corporate mortmain jurisdiction. But several of these things just aren't being administrated under corporate function. It's kind of nice to know that they have something they can't administrate. So when I write to them, I'd like to have my domestic tranquility as part of the estate. Now, am I going too slow or too fast for most of you? Am I doing okay? All right. Oh, here's a good one. It's page 91, up at the top. It says, a grant to the government or a subdivision thereof as for the use of the United States forever contains sufficient words to vest an absolute fee simple. Now, I want you to just pigeonhole this idea of a grant to the government. Okay? In the United States, the common law rule requiring words of inheritance in a conveyance to pass a fee simple has never been applied to a conveyance to a trustee. The estate taken by a trustee is measured by the duties he is required to perform. Like the articles. And the exigencies of the trust, and not by the presence or absence of words of inheritance. But yet there they are, still there. Hence, in any particular grant to a trustee of a fee simple title is necessary to the performance of the trust, a fee simple passes even though the word heirs was not used in the conveyance. Contrary rule is obtained in England, however. So the articles are the duties of the trustees in this estate. Supposed to have gold and silver, all those good things, you know, as money. That's a duty of the trustee. Very interesting. Gold and silver is the trust fund, the money, okay? If that's the money in this estate, what is a Federal Reserve note? Who is Federal Reserve note for? Yeah, but that's a name. What's the thing? We're looking for the things that the Constitution creates, not the name. 14th Amendment is another estate. It's a separate estate. It is a life estate. It is an estate created under the estate. If I own a fee simple absolute big chunk of land and I wanted to maintain control of half of it or 3/4 of it, and yet give maybe a quarter, sell a quarter, convey a quarter to someone else, but still get it back, I'd create a different estate, a life estate. You can have that estate until such and such time, then if you die or the conditions aren't met, I get it back. So I create another estate. That's what's happened. Another estate has been created. On page 207, the non-payment of taxes. Ooh, my. Now we're discussing a life tenant here. The mere refusal of the life tenant to pay taxes is not where there has been no actual sale for taxes, a ground for forfeiture of the life estate at the suit of the remainderman. Next underlined portion. Under some statutes, non-payment of taxes by a life tenant is regarded as committing waste, justifying forfeiture of his estate. Well, they're not going to have you forfeit your 14th Amendment estate, you know, so they just put you in jail. You've committed waste, now you're subject to certain laws and conditions. Okay, as a 14th Amendment citizen, a life tenant, you're committing waste. That's against law. Even in old common law, it was against the law. So you see, we're at the common law, but yet we can't get to the common law. It's a paradox. The common law we want to get to is up here, way up here, but yet we're still at the effect of the common law because it's still hovering over us. They've just diminished our estates and we didn't know about it. Have not been informed. Full disclosure did not take place. If it did, certainly wasn't in my civics class. Now, under life estates, there are remainders, okay? If I have a home in a life estate, I have to keep that home up in good condition for the remainders, whoever buys it, whoever gets it after me. A frequently stated rule on page 220, a frequently stated rule is that the remainder must be created by the same instrument which creates the life estate. In the ancestor, in order for the rule of Shelley's case to apply. Now, the rule of Shelley's case is long and drawn out, but it's a highly important rule. Under this rule, a will and codicil are considered one and the same instrument. Okay? It has been stated that the limitation to the heirs may be made by a power of appointment contained in the same instrument. So the rule in Shelley's case is important, and I'm not going to go into it because we have right here quite a bit to go through without going into everything I read and learned. Now we're getting to the point of codicil and will. Okay, all of a sudden that has popped up into our little picture. We're not quite sure where it fits, or even if it does fit, it might belong to some other puzzle, so we're going to sit it over here temporarily. And now we come to American Jurisprudence 2D, which is volume 23, Dedication to Desertion and Non-Support. But we're going to be looking up deeds. We're going to find out what a deed is. You see, all of these things that are very important when we're looking at a trust, at a use, we have to look at what is a will, what is a trust, because deeds start coming in, and so do grants, and so that everything can come into proper perspective. Okay, so in deeds, what if I was wrong? What if this was a deed? Actually, it is. Okay, it is a trust. Everything, it all comes in. Oh, up at the top here, grant is a synonym of conveyance. Do you remember back when Mr. Baldwin said it was a grant? 82.
82.
You missed that one. Remember Mr. Baldwin, the Justice Baldwin, said that the Constitution was a grant? I do believe I read that. Right here in deeds, it says, grant is a synonym of conveyance. So now Blackacre has been conveyed. We now know it is a grant. Okay, and we find this under deeds, so obviously it is a trust deed. Doesn't have to be, but it is. This is very flexible, folks, unlike the law we know today. You know, we can take the word deed out and still say this is a trust without the word deed in there. Somebody brings a grant in, okay, it's a grant too. Yes, it's a trust, it's a deed. There are things that it is not, but there are many things that it is. Assignments. Section 5, the term assignment, which signifies the act by which one person transfers to another or causes to vest in another his right of property or interest therein, is sometimes used synonymously with grant. Again, so as to operate as a conveyance of the title to real property. But is ordinarily limited in its application to the transfer of intangible rights, including those in action and rights in or connected with property, as distinguished from the property itself. The term assignment, unlike the term deed, does not signify an instrument under seal, and at common law, if not under seal, it was not sufficient to pass legal title to real property. This document is a document under seal. Oh, then we have mention of wills down at the bottom on page 83. Under deeds in Amjor, we have wills. Okay? Whether an instrument is a deed or a will depends primarily on its operation and not on its form or manner of execution. The essential characteristic of a testamentary interest is that it operates only upon and by reason of the death of the maker. During his lifetime, it is ambulatory and revocable. Hence, the maker, by its execution parts with no right and divests himself of no oh God, this is getting different, modicum. Modicum, how do you pronounce that word? Modicum? Modicum?
Modicum.
Modicum, okay. Of his estate. I see, I'm not all-knowing. I'm not, even though you might think I am. After you know what I know, you're going to be a know-it-all too. It is fundamental, on the other hand, in order that an instrument may be operative as a deed, that it pass a present interest, although it is not necessary that the grantee take a present estate in the property conveyed accordingly. This is defining deeds and wills. on the operation. What was the primary operation of the Constitution? Besides, the Founding Fathers did not have testamentary capacity. The statute of will says that. But now we're segueing into, we're bringing in a little bit of will stuff because we're going to find out that the 14th Amendment creates a codicil. It is a codicil. The Founding Fathers are obviously dead, folks. They must be dead because everybody is taking under a codicil and looks like a will part of our document. It's segued. They must have died. We're going to find out that the 14th Amendment is, you make an election to literally take under a will. Page 90, deeds are traditionally regarded as consisting of a number of formal parts, the first of which is known as the premise. The premise of a deed, sometimes designated the caption, embrace matters preceding the habendum clause, such as the recitals of the grantor, intention and motives for his deed, the names, designations, and descriptions of the parties, etc., the conditions expressed for the deed, words of grant, and the description of the property conveyed. Okay. Yeah, it defines it. Defines the property conveyed. The Constitution appears to have a habendum and all these things that are in deeds. Okay? We're looking at the construction of the instrument. This is how the Supreme Court looks at things. Words of grant on page 91. In order to transfer title, an instrument must contain apt words of grant, which manifest the grantor's intent to make a present conveyance of the land by his deed as distinguished from an intention to convey it at some future time. This showed no desire to do it in a future period of time. This was...
Here, let me do this real quick. I want to see... hold on.
Imagine that you are parents and you have a child or children, but you want to go out for the evening, and then you hire a babysitter to take care of them. So now you've just established a trust, okay? The value of the trust, or the res, which is what I told you that birth certificate represents, is the welfare of your children, which is very, very valuable. It's their lives, okay? The beneficiary of this trust is the children, because you're getting the babysitter to watch them for their benefit so they don't fall down the stairs, so they don't starve from not being able to cook for themselves, right? Or whatever they're not capable of doing independently. So they're the beneficiaries. They receive the benefits. The babysitter is the trustee. They are the ones that temporarily, they own the house and the kids, right? Because they're the responsible party. And they have all the duties. If shit goes wrong, it's on them. So you got to be careful if you're ever a trustee, right? Because all the burden's on your shoulders when you're the trustee. Now the parents who set up this whole thing, they are the grantors. Okay, they granted the trust and assigned all of the parties. Okay, so just to review that, a trust represents some kind of value. It could be property, assets, stocks, boats, anything.
Anyhow, That's why I wanted to share that with you as far as, that's the best little illustration of how a trust works. And this is where we've been duped in this country to where we, the people, are now the trustees when the government is supposed to be the trustee. That's the slick little trick. So anyways, I'm just curious to hear what Wes Huff has to say, why he's not a Roman Catholic. So I'm going to watch this real quick because, I don't know. He's suspicious to me.
Here is how imposter syndrome makes high IQ men never finish what they start.
You buy the... I get a lot of engagement on my content with Roman Catholics, and some of it I really appreciate. There are quite a few Roman Catholic voices out there online that I genuinely see as good and articulate and clear when it comes to a host of issues, despite the theological differences that I might hold as a Protestant and they would hold as a Roman Catholic. Trent Horn, for example, comes to mind. I've watched quite a bit of his content. I really like Trent. I like his demeanor. I appreciate the stuff he puts out online. I've been on Michael Knowles' show. I enjoyed our interaction, and he's been very supportive and encouraging towards me since. And so despite what some of you may have seen on like Roman Catholic Twitter or YouTube or whatever, I actually have never made a video solely focused on Protestant versus Roman Catholic distinctives. There are videos floating around out there on the internet of maybe me being asked about the subject in like a Q&A at a talk that I've given, but there aren't actually any on my channel. So it's those ones that are floating around online, they're me giving an off-the-cuff answer as opposed to focused and specific content like that you would find here on my personal platform. The closest I've ever come is discussing the topic of the canon of Scripture, where there's a difference when it comes to the Old Testament in a Roman Catholic Bible and in a Protestant Bible. But that's been an attempt to discuss and clarify the issue rather than like pitting the...
Notice how he's making the distinction. There is a difference between a Catholic Bible and a Protestant Bible. The good old King James Bible is different from the Catholic Bible.
Protestant position over and above the Roman Catholic one. But I wanted to take the time and stipulate why I'm a Protestant, why I am not a Roman Catholic in particular, because I get a lot of comments that say things like, Wes, I can't believe with all of your study of Scripture and church history, you still remain Protestant. And so I wanted to lay out the reasons why that is. The short answer is that it's because of my study of Scripture and church history that I am a convictional Protestant. But there's obviously things that need to be teased out there. And so I want to go through some of these things with you to clarify, okay, what are the reasons that I hold to a modern Protestant position rather than a modern Roman Catholic one? And the first one right off the bat is the issue of sufficiency. So first, sufficient meaning that in what they are and in what they do, they meet the needs entirely of their proposed intent. So if we're talking about the sufficiency of Scripture, in other words, and I've said this elsewhere, Scripture is ontologically unique. So though it contains both divine and human authorship, Scripture remains the speech of God. Nothing else we possess as a rule is akin to Scripture. Likewise, Scripture functions unrivaled in its authority. Nothing we possess as a rule does that. But both in what it does and in what it is, Scripture is unique.
I don't know.
And that uniqueness provides the basis for its sufficiency. Scripture intends to communicate to the body of Christ both the primary and infallible means for faith and practice.
All right.
So
I want you to see this. Let's see. Papal Bull. Is it called Unum Sanctum? Hold on, let me look. Oop, there it is. It is Unum Sanctum. Let me show you. Unum Sanctum. Unum Sanctum is one of the most frightening documents of history, and one of the most quoted as the primary document of the popes claiming their global power. It is an express trust deed. The last line reads, "Furthermore, we declare, we proclaim, we define that it is absolutely necessary for salvation that every human creature be subject to the Roman Pontiff. It is not only the first trust deed in history, but also the largest trust ever conceived, as it claims the whole planet and everything on it conveyed in trust. Triple Crown of Baal, aka the Papal Tiara, and Terregrinum, I don't even know how to pronounce it. Anyhow, in 1302, Pope Boniface issued his famous papal bull Unum Sanctum. Maybe that'll make it come up. Let me copy that. Bada boom. Try this. Try it that way. Here we go.
He was a very short-tempered man and would be physically violent, and that actually led to some strong changes in regards to papal power through church history. Boniface took it up a notch for the popes. One of his famous quotes that he made was, "We declare," I'm going to read it here, "we declare, say, define, and pronounce that it is absolutely necessary for the salvation of every human creature to be subject to the Roman Pontiff." Okay, so he was making it clear that you must fall under the authority of the Pope. And all matters, temporal and eternal, spiritual, political, all matters are beneath the Pope of Rome. That kind of a claim was pretty strong. It hadn't been made. There were people that felt that way, but it wasn't actually issued in official documents until Pope Boniface VIII came along. Now, why did that happen? There was a conflict between King Philip IV of France and Pope Boniface. Basically, what the King of France wanted to do was start taxing the Catholic Church. He saw the great wealth of the Roman Catholic Church and felt like if they're going to meddle in the government affairs, they should have to pay a portion into the governments. They should be supporting the governments. And so he required payment from the Catholic churches in France. Pope Boniface did not like this. He was very angry about it. And so he told the clergymen in France there not to pay anything to the King of France. As a result, the King of France no longer allowed gold or precious stones or silver to be sent to the Papal States that the Pope was in charge of. So that cut off a lot of revenue to the Pope. So if the Pope's not going to pay some taxes in France to the King, then none of the wealth in France is going to go to the Pope. So you follow the money and you'll see this great conflict between the Pope Boniface, and King Philip IV. So they're going back and forth fighting over this money. And Pope Boniface issues this decree, this declaration. I'm going to try to pronounce it. It's Ausculta Fili. Ausculta Fili is how it's pronounced. And what that said is that every government power, everyone must be subject to the Pope of Rome. When this document that the Pope had signed, put a seal on it, everything, it's official, when that was sent to Paris, right away, as soon as it got there, Philip IV took it and threw it into the flames. He threw it in the fire and burned it up. He didn't want anything to do with that. He was rejecting the authority of Boniface. So Boniface then released the Unum Sanctum, which said everyone is beneath the Pope of Rome. It said what he had said before, but with a little more gusto, basically. He really drove the point home that everyone's beneath him, and even your salvation depends on you being beneath him. So that quote I gave you that he's famous for, it all came as a result of this conflict with the King of France at that time. He was trying to show himself as the most powerful man on earth over all matters. Okay, spiritual, carnal, everything.
For all nations have drunk of the wine of the wrath of her fornication, and the kings of the earth have committed fornication with her, and the merchants of the earth are waxed rich through the abundance of her delicacies. And I heard another voice from heaven saying, Come out of her, my people, that ye be not partakers of her sins, and that ye receive not of her plagues. For her sins have reached unto heaven, and God hath remembered her iniquities. How much...
I mean, you know, could you be any more against, graven images? I mean, your whole palace is nothing but graven images. It's beyond ridiculous.
But she hath glorified herself and lived deliciously, so much torment and sorrow give her. For she saith in her heart, I sit a queen, and am no widow, and shall see no sorrow. Therefore shall her plagues come in one day, death and mourning and famine, and she shall be utterly burned with fire. For strong is the Lord God who judgeth her. And the kings of the earth who have committed fornication and lived deliciously with her shall bewail her and lament for her when they shall see the smoke of her burning, standing afar off for the fear of her torment, saying, Alas, alas, that great city Babylon, that mighty city, for in 1 hour is thy judgment come. And the merchants of the earth shall weep and mourn over her, for no man buyeth their merchandise any more. And in her was found the blood of prophets, and of saints, and of all that were slain upon the earth.
Amen. Hold on. Boom. There's a one little dude that...
The papacy appeared outwardly strong, but beneath the surface it was dangerously weakened. By the late 13th century, the papacy appeared outwardly strong, but beneath the surface it was dangerously weakened. Over decades, popes had crushed most internal criticism and dissent, yet they did so at a heavy cost. Their moral authority had eroded. When the papacy confronted powerful monarchs, it could no longer rely on the reflexive obedience that earlier popes had commanded. This vulnerability was laid bare in the dramatic struggle between Pope Boniface VIII and King Philip IV of France, known to history as Philip the Fair, the most formidable ruler in Europe at the time. the clash was almost inevitable. Throughout the Middle Ages, royal power in Western Europe had steadily expanded, especially in France and England. By 1300, kings ruled through centralized governments with growing bureaucracies and increasingly sophisticated systems of taxation. The papacy, though still wealthy and influential, was compromised by political entanglements, resentment toward its riches, and widespread frustration with its interference in secular affairs. The stage was set for a confrontation between a determined pope and an ambitious king. The immediate spark was money. The French church was enormously wealthy, and its clergy occupied an ambiguous position. As churchmen, they owed obedience to the pope, but as landholders, they were also vassals of the French king. Traditionally, clergy paid certain feudal dues to the crown, and popes had authorized special taxes to support crusades. Philip, perpetually short of funds and eager to expand royal authority, decided in the mid-1290s to tax the clergy directly, without papal approval and without any pretense of crusading. In 1295, he demanded heavy new payments. When some church leaders resisted and appealed to Rome, Boniface found himself drawn into a conflict he could not avoid. The personalities of the two men ensured that compromise would be difficult. Philip, whose epithet referred only to his appearance, was described by contemporaries as cold, ruthless, and relentlessly calculating, a political genius with an iron will. He debased the currency, expanded the use of judicial torture, and invented new taxes, all in the service of royal power. Boniface, by contrast, was intensely conscious of papal authority and deeply committed to the idea that the Pope stood above all secular rulers. He had risen to power after the resignation of the saintly but ineffective Celestine V, whom Boniface later imprisoned. A member of a powerful Italian family, Boniface intended to strengthen both the papacy and his own kin. Even later admirers of the Church, like Dante, condemned him as corrupt and arrogant. The first round came in 1296, when Boniface issued a decree threatening excommunication for any ruler who taxed clergy without papal permission. Philip's response was swift and brutal. He prohibited the export of money from France, instantly cutting off the enormous flow of church revenues to Rome. Faced with financial disaster, Boniface backed down and allowed the king to collect the taxes. The Pope had avoided immediate defeat, but at the price of exposing papal weakness. The conflict soon escalated. In 1300, Philip arrested a French bishop for treason. The bishop was indeed conspiring against the crown, but Boniface insisted that clergy could be tried only in church courts, regardless of the crime. Philip demanded that the Pope first strip the bishop of his clerical status so that a secular trial could proceed. When Boniface refused, Philip unleashed a propaganda campaign unlike anything seen before, accusing the Pope of corruption, abuse of power, and unlawful interference in royal affairs. Furious, Boniface made his final stand. In November 1302, he issued Unam Sanctum, one of the most extreme assertions of papal authority ever written. The decree proclaimed that the Pope held supreme power over all secular rulers and that submission to the Roman pontiff was necessary for salvation. 2 centuries earlier, such a declaration might have brought a king to his knees. But times had changed. In France, public opinion, including much of the clergy, stood firmly behind Philip. Philip responded with shocking audacity. Accusing Boniface of heresy, corruption, and tyranny, he sent armed agents to seize the Pope at his residence in Anagni in northern Italy, planning to haul him to France for trial. The elderly pontiff was captured and humiliated, though his captors ultimately released him, fearing he was too ill to survive the journey. The damage, however, was done. Broken in spirit and health, Boniface returned to Rome and died shortly thereafter, reportedly confused and grief-stricken. The confrontation marked a turning point. Boniface's defeat signaled the collapse of papal political supremacy. Never again would a pope seriously expect a major king to submit to excommunication or papal commands. In the years that followed, the Avignon papacy and the Great Western Schism, the authority of Rome would weaken even further. But the decisive blow had already been struck in the disastrous showdown between Pope Boniface VIII and Philip the Fair of France.
Philip the Fair of France. That sounds gay. anyway. Where's my girl? But yeah, that's what are the chances that the Antichrist is going to resurrect this document? That's why this is a kind of important piece of history there that never manages to be brought up in school.
Was right then there.
But you can see why there is absolutely a mission to subvert this trust that is our Constitution. This is why they need we the people to destroy this document ourselves by our own free will. So, because there are laws of nature that even the unclean spirits must obey him. Satan had to come and ask for a permit to mess with Job. So, this is why God's law stands at all times. Never ever does it not. You know what I mean? These 10 Commandments, they're never going to go away. They're entwined with nature, with creation itself, and with laws of physics and all that. So this is why, this is important. Are we, by obeying a bunch of ungodly laws, are we behaving wickedly and lawlessly without knowing because we're ignorant? Something to think about. Could I be an idolater by accident?
And now. Always now. Oh, and down here in the bottom in section 20, although words of inheritance such as to the and his heirs and assigns forever are no longer necessary to passive fee simple, the use of such words strengthens the reading of a deed to passive fee simple title. Okay, so they strengthened even today, and not to amalgamum of lesser states. Addendum, let's see, word covenant. Page 575. This comes from Amjor 2D again. We will find this under covenants. Covenants, conditions, etc. We have a covenant here. There is a covenant sitting right in here. Insure and secure. Those words are words of guarantee, insurance. The term covenant,
or surety,
in its wide sense, is used to indicate a contract, while the more specific application of the term imports an agreement deduced to writing and duly executed, whereby one or more of the parties named therein engages that a named act is already performed or is to be performed sometime in the future. A covenant may also call for the performance or non-performance of some specified duty, and may constitute an agreement to do or not to do a particular act. Is that in the Constitution?
Yes.
We have a covenant.
That's a moral obligation.
The term covenant is now used primarily to in connection with promises, in conveyances or other instruments pertaining to real estate. You know, it says now, but not then. Then this was a covenant. Again, a covenant at common law imports an instrument under seal. We have a covenant. Duration of covenant on the next page, 577 of Amjor. A A covenant is therefore extinguished when the estate ceases. We are in imminent danger. Wouldn't you say so? This is still on the books. It's still in black and white. It has not openly been repealed. But I have a very sneaking suspicion that our government is going to take our estate away from us on or in black and white, or out of black and white, whatever way you want to say it. We are in imminent danger. We don't know what we have been arguing and fighting for until now. We can now look into the future. Okay, page 580.
And it is my position that our current government is absolutely part of the corporation. Okay? Hold on. I mean, and I'm telling you right now, the boogeyman is the motherfucking Catholic Church. Straight up. Let's just pull the mask off of this Scooby-Doo. Straight up. That's my position. It's clear as day to me. I think Scripture couldn't be more clear. And I love that God hates all of this religious nonsense of fucking goofballs running around in funny hats and red shoes and little dresses. And I love that God hates that. He hates it. I love it. So, anyway. We don't have to wear little dresses. Okay, who was that? Oh, yeah, okay. Ned Beatty Network monologue. Boom. This is true right here.
What if you could make a song using only your voice? Let's start with the drums.
So, yeah, my position is the head of the network is the Catholic Church. Which is, that's Satan's church. The tares amongst the wheat.
You have meddled with the primal forces of nature, Mr. Beale, and I won't have it! Is that clear? You think you merely stopped a business deal? That is not the case. The Arabs have taken billions of dollars out of this country, and now they must put it back. It is ebb and flow, tidal gravity. It is ecological balance. You are an old man who thinks in terms of nations and peoples. There are no nations. There are no peoples. There are no Russians. There are no Arabs. There are no third worlds. There is no West. There is only one holistic system of systems. One vast and immane, interwoven, interacting, multivariate, multinational dominion of dollars. Petrodollars, electrodollars, multi-dollars, Reichmarks, Rins, rubles, pounds, and shekels.
The power of the printing press, so to speak.
It is the international system of currency which determines the totality of life on this planet. That is the natural order of things today. That is the atomic and subatomic and galactic structure of things today. And you have meddled with the primal forces of nature. And you will atone. Am I getting through to you, Mr. Beale? You get up on your little 21-inch screen and howl about America and democracy. There is no America. There is no democracy. There is only IBM and ITT and AT&T and DuPont, Dow, Union Carbide, and Exxon. Those are the nations of the world today. What do you think the Russians talk about in their councils of state? Karl Marx? They get out their linear programming charts, statistical decision theories, Minimax solutions, and compute the price-cost probabilities of their transactions and investments, just like we do. We no longer live in a world of nations and ideologies, Mr. Beale. The world is a college of corporations, inexorably determined by the immutable bylaws of business. The world is a business, Mr. Beale. It has been since...
Sure is. And now here he comes. This is the, the way the devil plays.
Since man crawled out of the slime.
Since man crawled out of the slime, you filthy little animal.
And our children will live, Mr. Beale, to see that perfect world in which there's no war or famine, oppression or brutality. One vast and ecumenical holding company for whom all men will work to serve a common profit, in which all men will hold a share of stock, all necessities provided, all anxieties tranquilized, all boredom amused. And I have chosen you, Mr. Beale, to preach this evangel.
Why me?
Because you're on television, dummy. 60 million people watch you every night of the week, Monday through Friday.
I have seen the face of God.
You just might be right, Mr. Beale.
Man is God. So, yep, that's the game, folks. Who gets to print the money? It controls the whole state of things on this planet.
84. Let's see, second sentence. A covenant is viewed as implied in nature when its existence is inferred by legal construction from the use of certain words and phrases. Certain words and phrases. Insure and secure. These words are very important because they have a legal meaning. Every word in this document has a legal meaning when it comes to estates and when it comes to the construction of the written instrument itself. All the power of the entire Constitution is right here, not elsewhere. Because this created the corporate function. This created the trust function. This gave all of it power. Page 585, second paragraph, or let's see. Implied covenants can arise and will prevail only where there is no exception on the subject matter of the implied covenant. This is something you should look into at your leisure. Implied covenants still count, even if those words are implied, they count.
That's why, when everything's left up to the judge's discretion rather than written law, that's where many things can be implied. Because you don't exercise your rights. Ignorance being no excuse for the law, and law of Lache, boom, buries you right there. You don't have no rights.
On the next page, 592, reflects upon the 14th Amendment, okay, the marked area. At common law, no person may claim the benefit of any covenant or condition except where he is a party or privy thereto. As a 14th Amendment citizen, you are not party or privy there to this estate, so therefore you cannot claim the covenant. You are barred from it.
Hopefully this is sinking in that, a 14th Amendment citizen is totally different than a citizen of America, a citizen of whatever state that they live in. There is a difference to their estate, what they inherit.
Are you getting to understand why we're having a little frustration in court? We're having a lot of this. Page 594, section 23 of covenants. The benefit of a covenant that runs with the land descends to the heirs, and they, as well as devisees and covenantees, are entitled to enforce such a covenant unless an evident intention is manifest to confine it to the covenantee. In the event a real covenant is breached, then it descends to the heirs. The latter may institute appropriate legal action to recover damages for such breach. However, if the covenant is personal, it remains with the covenantee or his executor or administrator. It does not descend to the heir. Try to go through this. On page 617 of Covenants and Condition, 20 M. Jur. 2D, section 45, breach of covenants generally. The broad rule is that a covenant or condition is broken by any single omission of duty or any act that contravenes the provisions of the agreement entered into between the parties. We have a breach of covenant. This is what we entered into, and it has now been broken by many acts of omission and duties toward this covenant. Not toward the 14th Amendment, but toward this specific one. Page 629, we're discussing paramount titles. This is a paramount title, okay? 14th Amendment citizenship is in the state of inferior title. We're going to find that out. The mere existence of a paramount title which has never been asserted generally does not amount to a constructive eviction. We've got to assert these titles, okay, which will support an action for breach of a general covenant of warranty. Or, as the rule is sometimes stated, there can be no recovery in an action for breach of the covenant if the paramount title has not been hostilely asserted. So we're going to have to hostilely assert our paramount titles. Section 59, where the paramount title is in a governmental entity. Where the paramount outstanding title is in a government, this fact of itself constitutes such a constructive eviction as amounts to a breach of the covenant of warranty. Now, wasn't that nice of them to put that right there in black and white? So they have breached the covenant, they have breached the covenant of warranty, evicting us. We're just going to have to go back and assert our titles again. A grantee by warranty deed executed by a private person to lands owned by the United States cannot take possession without becoming a wrongdoer. Here's your allodial titles. And hence his right of action accrues immediately to recover for a breach of this warranty, and is not dependent on eviction or any future event, but under a statute providing that a warranty in actual possession of the premises conveyed shall have no right of action on a covenant of warranty until the party threatening the warranty's possession shall have commenced an action to obtain possession. We'll stop right there. Okay, so this is all about the breach of warranties and the covenants. Now, the next section is wills, but before I get to that, I want to read a definition out of Webster's 1828 dictionary of fee simple. Okay, because the question has arisen that fee was feudal, etc., and that it wasn't an allodial title. Okay. We'll skip some of this. Let's see, it's deduced from Saxon cattle, property, and fee, or primarily a loan of land, an estate in trust. Fee simple absolute, an estate in trust. Granted by a prince or lord to be held by the grantee on condition of personal service or other condition. I'm not too sure what the conditions are on the estate here that we have. And if the grantee or tenant failed to perform the conditions, the land reverted to the lord or donor, called the landlord or the landlord. In America, where lands are not generally held of a superior, a fee or fee simple is an estate in which the owner has the whole property without any condition annexed to the tenure. In the United States, an estate in fee or fee simple is what is called in English law an allodial estate, an estate held by a person in his own right and descendable to the heirs in general. So a fee simple absolute in the United States is allodial title. We're now going to discussion on wills, because like I said, I was looking to find out what was the Constitution. And the question had come up about the question had come up about what was a 1040? Was it a will? And I have to say I don't believe so. But in researching it, I found a lot of interesting things on wills, so we're going to go into that. Pardon me. Okay, page 275 of 79 Amjur 2D on wills. Okay, in there in the second sentence it says, by common law there were but two modes of acquiring title to real estate, namely by descent or by purchase. Where a person takes as heir at law, he takes by descent. But when he takes title to land by his own act or agreement, he is a purchaser. A little confused. Okay. Although in common application of the term, he may not have paid a consideration for it. A devisee who takes an estate different from what the law would cast upon him as heir is a purchaser. You can look at the 14th Amendment as being purchased. The estate is purchased because you take something that is other than what would be cast upon you by the law. This is the law. Okay? And as such, under the feudal system, was exempt from the restraints imposed upon heirs in their minority, such as wardships and right of marriage. Although the feudal system had passed away, hardly, I don't think so. Many distinctions of this character are still of recognized importance. It certainly is, because it hasn't passed away. It is still in existence, and I look at the world today, and we are living in feudal times. Accordingly, the doctrine of common law, even after the passage of enabling statutes, was that a will was in the nature of a conveyance, declaring the uses purchase and not by descent. So if your father leaves you something in his will and you take it, you did not inherit it. You purchased it. Legally, you purchased it. You did not inherit. If he did not leave a will and you got his estate, then you inherited it. It fell upon you by descent and distribution. Otherwise, you purchased your estate. Just that simple. Can't get around it. Page 285. The animus testandi does not depend upon an understanding by the testator that he is making a will. Okay, the Founding Fathers created a trust, okay, and it was complete until after the Civil War. Then they start adding amendments. Now, if there is a trust, there's a possibility that the amendments could be construed as codicils to the will, or codicils of a will. It is a trust, and there are such things as wills or trusts with wills attached, or vice versa. Okay, so if we begin to look at the 14th Amendment as a codicil changes the intent of the testator or the trustor or whoever created it. 14th Amendment literally did change the intent of this right here. And they didn't have to know they were making a will, as this little paragraph says. The fact that the testator did not intend the language to operate as a codicil is immaterial on the question whether the instrument is in fact a codicil. Okay? So now we're going to start looking at the 14th Amendment as the codicil. Page 297 brings up the idea or thought of an instrument of dual character. Okay? Down toward the bottom it says, an instrument in writing may be a contract respecting property in one part and testamentary in another part in relation to other and distinct property. Here we have a definition and description of this estate as compared to the estate that we're going to see the 14th Amendment create. On page 314, again, section 55 there under wills, it says, property does not pass under a will by any natural right. There go your inherent rights, your vested rights, everything that comes into from the Magna Carta. Okay, so if you're a 14th Amendment citizen getting all your rights and privileges under a codicil, you do not have any natural rights. Your natural rights reside right here. You've given them all up for the privileges that the government has bestowed upon you. This is a state law. I didn't make this up. In these pages that you have, when you go through them at your leisure, you'll see that I have encircled or bracketed the footnotes. And a lot of these footnotes have some wonderful things to say or to look up that relate back to the paragraph. So study these intensely. Really get into it, because there's more here than what I'm giving you. And even that, what I'm giving you, there is a world more. I couldn't include everything in this lecture. Okay, but I figured this is the bare necessities for you to have and understand, and from here you can branch out. And if you get a letter from the whoever, the FTB, the State Board of Equalization, or the IRS, if you stay focused on your estate instead of them sucking you into the regulations that are established under the 14th Amendment for that particular estate, hopefully you will feel much better. Instead of arguing their argument, you will be arguing yours. At least I find that to be of value. If the testator intended to make an entire disposition of his property in substitution of that made by a prior will, he probably would have proceeded to make a new will rather than a codicil. Okay, so that applies to the Constitution. second paragraph. While a codicil is a latter will in the broad sense, it is not an independent will, but purports by its form to be an addition to a prior will. Okay, so we're looking at the Constitution now and say, okay, the original form was a prior will. Now we're adding the 14th Amendment as a codicil, changing the intent. Several clauses of the two instruments should, if possible, be harmonized so as to give effect to every portion of each instrument. Now we're separating things, okay? We're separating the two estates. They both have to coincide, truly, okay? Because the 14th Amendment is one state, but it comes from this estate. But in our minds, we have to separate them so that we can tell the difference. Okay, and in our separation, they still have to...
I'm going to get on out of here. I got to run into town and stuff. So anyhow, I hope you totally check out Bernice Speakman and check out her videos. You know, it's good information to learn and know about. So if you want to be somebody that is able to exercise your rights and be able to, you know, properly talk to cops and judges and deal with yourself in legal matters appropriately so you don't get your dumb ass in trouble. So anyway, I hope y'all have a good day, and you know,